Hello, everybody. Welcome. Please can I welcome everyone to the meeting of the Licensing Subcommittee taking place from the Walton Suite, Winchester Guildhall. The time is 11 o'clock. My name is Councillor Johnny Morris, one of the committee members of this particular Licensing Subcommittee. The open parts of this meeting are being live streamed and recorded to the Council's YouTube channel. Subtitles are available and advice on how to turn this on is set out on our website. Please can everyone ensure their mobile phones are on silent or switched off entirely. In the unlikely event that it is necessary to evacuate the building, the fire alarm will sound. Please follow all the instructions given to you by our team. Now moving on to the agenda, disclosure of interests. Do any members or officers have any interest they wish to declare? Okay, then application for review of premises licence, Boomtown Fair, Mathley Bowl, Alsford Road, Winchester. Report number LR 589. Okay. The hearings regulations require that the hearing should take the form of a discussion led by the subcommittee and that cross-examination will not normally be allowed. We're following the adopted procedure for these hearings, which is set out on the reverse of the agenda paper. Each party will be allowed equal maximum time to exercise their rights at the hearing. I will exercise my discretion to allow additional time if necessary, taking into account the requirement to allow all parties equal maximum time. Only those points contained in the written representations of the report and supplementary documents can be raised. No new evidence can be considered except with the agreement of all parties. I am Councillor Johnny Morris, this is Councillor Brian Laming and Councillor Paula Langford-Smith. The subcommittee has read all the written comments on the application for review, which are included in the report. I understand that there are representations from other persons who wish to address the subcommittee and representations from Boomtown. We can only consider issues relating to the 4 licensing objectives: prevention of crime and disorder, public safety, prevention of public nuisance, and protection of children. The subcommittee will also have regard to the national guidance and the council's licensing policy. I hand over to the licensing manager to introduce the report. Thank you.
Chair, just before we do so, you may have seen me have some conversation with the respondent solicitor, Mr. Phipps. Unfortunately, some representatives that you shall be hearing from later today have submitted late evidence, and that requires basically a position as to whether or not this evidence should be admitted to you. It is late, and in the spirit of the Licensing Act, each party should have full disclosure of the representations and the case being made for or against them. In this instance, it's unfortunate that 2 individuals have provided late evidence, a Mr. Payne and a Mr. Jones. And I did have conversations with the respondent solicitor as to whether or not they would be agreeable in this unfortunate situation to admit the evidence. As you've rightly said in your introduction, it needs the consent of all parties as to whether or not late evidence should be admitted. Now we are where we are. We've had conversations which delayed proceedings a little bit. And in accordance with the regulations, we do need that consent. Kindly, the respondent here, Boomtown, have agreed to that evidence being admitted. I'm sure Mr. Phipps may want to make some points about that before I pass it across to you to consider. But that is the situation. We do have the consent in this particular regards, but going forwards, it's not the best approach to dealing with hearings. Obviously, individuals should be entitled to understand the case before them, come fully prepared with their counsel or their legal advisors. In this instance, some of the material is quite substantive. So I will pass it across, but I'm sure you might want to hear from Mr. Phipps before I do so.
Yes, thank you. You'll recall we were here before Christmas and we were adjourned in unfortunate circumstances at that juncture. The idea of adjourning today is obviously extremely unattractive. We have had this to deal with for many months now, and so it is particularly unfortunate. But in the circumstances, weighing up effectively the prejudice that we might suffer from further delay against the inclusion of the materials, we consent. I hope I don't speak too flippantly when I say that there's a significant difference between consent and happiness with the proposition, but consent is given. May I make one brief point, which I hope will not arise, but I'll flag it now. As you will have seen from Mr. Jones's representations, and he has sought to include additional material this morning, those attend to what I will call ecology issues. I appreciate it's broader than that, but I hope the summary is not misplaced. Our ecology expert is online. So the one person on our side of the desk who is the expert in the field in which Mr. Jones will be addressing you later is the one person who hasn't seen the document, because we've been handed a physical copy of it this morning. We haven't even been given the courtesy of it on email or anything. I have read it. I'm not needing to ask you for a delay today for the expert to consider it, but I'm just wanting to flag that as she hasn't seen it, if something were to arise that isn't immediately apparent from the document, I might just ask to need a little time during the course of the hearing to speak to her outside of the formal hearing. I'm not expecting that. If I was, I'd do it now.
So with that in mind, what I shall be handing to you are statistics and another reference to the Countryside and Wildlife Act of 1981 and some statistics prepared by Mr. Jones in relation to species of birds. It's a two-sided page of A4. I shall also be handing from you to you rather from Mr. Payne the reasons for refusal from a planning application, which no doubt we shall hear about, where the officer recommended refusal. Three particular mooted reasons for refusal were proposed by the officer. However, you shall also hear that that application was withdrawn, so it doesn't actually form a formal decision notice of the South Downs National Park Authority. So that's what I shall be handing up, so everyone is aware of what is being handed to the chair and members.
Can I ask, since I think Mr. Payne is present, whether he could include the new information within his talk to the committee to save us the time of reading it in full, if he's going to be making it that same information made verbally as well.
Yeah, no doubt the individuals in question will be referring to that. Otherwise, one could reasonably surmise why would they be putting it into the hearing. So yes, probably ask your questions about the relevance or otherwise of that new information.
In that case, I'd like everyone to bear with us for a couple of minutes while we actually read what we've been given. Thank you.
Chairman, it may be wise if we adjourn them for 10 minutes and then pause the live stream whilst you've got the opportunity to read that. This is the point that I've made, obviously, that it causes delay to all individuals. So in this regard, I would suggest probably adjourning for 10 minutes so you've got the chance to read.
I agree with that suggestion, and we'll read as quickly as we can. Thank you.
Thank you.
Welcome back. We've now read the additional submissions made, and I shall now hand over to the licensing manager to introduce the report. Thank you.
Thank you, Chair. This report relates to an application to review the premises licence under Section 51 of the Licensing Act 2003 for Boomtown Fair held annually at Matterley Bowl, Alsford Road, Winchester. The application was submitted to the Licensing Authority and sent to all responsible authorities and the premises licence holder on the 2nd of October 2024 by Hampshire Isle White Constabulary, a responsible authority under Section 13 of the Licensing Act 2003. The application detailed concerns in relation to the prevention of crime and disorder and public safety licensing objectives following the death of a 22-year-old male at the 2024 event. No representations were received from any other responsible authority. 17 valid representations were received from other persons, mainly in reference to the public nuisance licensing objective. These can be found at Appendix 1 on pages 15 to 54 of the report pack. On the 21st of November 2024, the Licensing Authority were given notice by the Chief Officer of Police, Hampshire Isle White Constabulary, that they were withdraw their application, stating that he wishes to seek continued engagement and mediation with the operators and their legal representatives to reach a suitable outcome that is agreeable to all parties by addressing the issues and concerns that have been highlighted within the application. It is hoped that this outcome can be achieved prior to next year's event. The Licensing Subcommittee hearing on the 25th of November 2024 was opened and adjourned to allow all parties to consider the remainder of the review in light of the police's withdrawal of representations. The hearing today is to consider the 17 representations from other persons only. Boomtown Festival UK Limited have had a premises licence Prem 773 since the 30th of July 2019. The licence authorises regulated entertainment, late night refreshment and supply of alcohol on one occasion per calendar year for 6 consecutive days. A full copy of the premises licence can be found at Appendix 2 on pages 55 to 71 of the report pack. As members will be aware, Matterley Bowl and surrounding land is in the South Downs National Park. The subcommittee have a duty to seek to further the purposes of the park when making a decision, as detailed on pages 10 and 11 of the report. The South Downs National Park Authority, as the planning authority, were consulted on the application but did not submit a formal representation. Several of the representations refer to the expiry of the planning permission and reference to the council's policy that states at para 1.4, prior to submitting an application to the licensing authority, the applicant should ensure that there is appropriate current planning permission for the hours and activities for which application is being made. In this case, Boomtown are not making the application, but should they hold an event without planning permission, would be subject to planning enforcement under planning legislation. They would not be subject to enforcement under licensing legislation. Under the Section 182 guidance, under the Licensing Act 2003, page 126 states that the planning and licensing regimes involve consideration of different, albeit related, matters. Licensing committees are not bound by decisions made by a planning committee and vice versa. The South Downs National Park Authority have previously acknowledged that the planning and licensing regimes are separate. Whilst licensing is defined in legislation, planning has broader considerations, and therefore the two regimes may not come to the same conclusions. The subcommittee are required to balance promoting the provision of entertainment and addressing concerns relating to the licensing objectives. Although not a formal party to the hearing, Abby Toms, the Environmental Protection Manager, and Zoe Goldsmith, the ecologist, both from Winchester City Council, have been invited to attend the hearing today to answer any technical questions by the members. I must emphasise, though, that they are here for technical questions only. They're not here to provide an opinion, nor guide members with their decision, as they have both not made a formal representation. When making its decision, the subcommittee must take following steps it considers appropriate to promote the licensing objectives. 1. Modify the conditions attached to the premises licence, either permanently or temporarily for a period not exceeding 3 months. 2. Exclude a licensable activity from the premises licence, either permanently or temporarily for a period not exceeding 3 months. 3. Remove the designated premises supervisor from the premises licence. 4. Suspend the premises licence for a period not exceeding 3 months. Or 5. Revoke the premises licence. Members are reminded that should they consider amending conditions attached to the premises licence to promote the licensing objectives, that this is discussed during the hearing so that the premises licence holder has an opportunity to respond and explain how this may affect their business operation. That concludes my report. Thank you, Chair.
Thank you. I think my fellow councillors requested some legal advice, which I think we will take now regarding the submission, one of the new submissions.
Thank you, Chair. Yes, I understand South Downs National Park have not made a representation, but the new information that we have appears to be an application to be refused for reasons set out below. And I understand that this is from an application that was subsequently withdrawn.
That's correct.
What weight should we as a committee attach to this information? Thank you.
That's a difficult question because matters of weight are for you. So ultimately it's for you when you go away and retire. Everything you hear, all the evidence you've read and what you've seen and know of the site yourself, you take away and you put it into the decision-making toolbox, as you were, and come up with a decision that you feel is right in the circumstances. So in specifically relation to the actual officer's report, what we do know is that was an officer recommendation, which was to go before members of the South Downs National Park Authority. So it was not determinative. It was not delegated to that officer to make the decision. It would have been for the South Downs National Park Authority and its members to make the decision. As a result of that recommendation, no doubt Mr. Phipps and others will mention this, it was withdrawn. So you're left with a situation where an officer recommendation was made to refuse, but no final decision notice, i.e. refusal notice or planning permission, was actually granted. With that in mind, what you can do to help you come up with an idea of what weight you put upon it, the licensing manager beforehand mentioned that what we now know is the Section 182 guidance, and the Section 182 guidance makes it quite clear at paragraph 14.65. The planning and licensing regimes involve consideration of different, albeit related matters. Licensing committees are not bound by the decisions made by a planning committee. So even if that did amount to a refusal, you would not be bound by it. Here is the lesser step. It was never determined. So I simply guide you towards that particular statutory guidance and put what weight you see fit on that particular document.
Can I just clarify for my own benefit? It was not withdrawn because it was factually inaccurate then?
An applicant can withdraw a planning application for any reason whatsoever. The planning authority or South Downs National Park Authority may not know what those reasons were. It's entirely within a gift of an applicant at any point in time to withdraw an application, be it for a premises licence or a planning permission or for any other type of licence. The individuals or the corporation applying for a particular grant of a licence or permission from the council may not ever express to a council, a planning authority, or indeed a licensing authority what the reasons are.
Okay, I think happy to move on. Because unusual circumstances, the applicant review isn't, we don't have one for this particular thing, so we should move straight on to. Oh, Councillor Lemming.
I just asked when that application was submitted and when it was withdrawn.
That's in the actual bundle, so I'm gonna have to flick through many pages and yeah, forgive me, I haven't got an encyclopedic knowledge of every date, and I'm sure Mr. Phipps might be able to put a picture.
2020, sir.
Much obliged, thank you.
Okay, so I think the next step is the responsible authorities and the various authorities listed here. No new submissions have been made, so we go straight to any other persons. So if going through the list in the order they're given here, if Mr. Terence Jones would like to speak to us. Thank you very much.
Good morning, all. Firstly, can I thank the Boomtown team for agreeing to accept my last-minute piece of paper, which has got some statistics on it that I didn't have when we last met a couple of months ago, and I appreciate you taking that line, Mr. Phipps. I'm here to ask you to revoke the licence that the Boomtown Festival are applying for on the grounds of prevention of crime and disorder. What I'm going to say in the next few minutes is not to do with ecology, as Mr. Phipps said, it's to do with crime and disorder. And my case is that the Act of Boomtown is harmful to protected birds, especially to a list of red listed birds that we're fortunate are on Boomtown. And Section 1 of the Countryside and Wildlife Act 1981 says, if any person intentionally kills, injures or takes any wild bird, takes, damages or destroys the nest of any wild bird whilst that nest is being built or used, or takes or destroys an egg of any wild bird, they shall be guilty of an offence, and then goes on to say that you can go to prison for that. So this is a serious legal act that I'm talking about. It relates to ecology, but it is an act which I think we need to take notice of. And I recognise that your licence relates to the act of the festival itself, which is for 6 days. But I urge you to look at the fact that the festival takes 6 weeks to build up, has a week of festival and then 3 weeks to pull down. And so that if the license is granted, there is a 9-week impact on those birds and other wildlife that is protected by the Act I've mentioned. And it's the impact of 70,000 people in 1 week that you must consider, plus the setup and knockdown time. I want to impress you the scale of this event in terms of wildlife. It isn't solely confined to the Matterley Bowl. It covers 444 hectares. It's nearly 2 miles by a mile big. This is a big event. In addition to the bowl area, there's various villages, car parking, attendant temporary roads, lighting and other services. During the construction period, there is a caravan village built to host the construction workers. Previous applications I've seen, there are up to 2,000 construction workers on that site for the 5-week setup period. They're building temporary roads. They have lighting on the farm for all of those weeks prior to the actual festival through the night. They're building several kilometres of fences, roads and so on. This is a major construction site in the middle of the Hampshire countryside, and that is the impact that I'm asking you to look at. Immediately before the festival, somewhere between 200 and 250 hectares of grassland is cut to enable camping. That is disastrous for ground nesting birds, such as the skylark and the corn bunting. And in the papers I submitted several weeks ago, and in the handout I've just given you, you can see the dates that those birds nest and when they fledge, and that there is no way that those birds are not damaged by a construction program of this size on that site. I've lived just over a mile from Matterley for the past 39 years. I know the area well. I've been a bird watcher since I'm 8. I've done all sorts of bird surveys in that area, including for the British Trust of Ornithologists Bird Atlas, and I'll answer any questions you want of my competence to talk about this. But you should note that Matterley contains red listed birds. Those are the birds that are protected by the government's biodiversity programme, the highest level of protection, and it has about 44% of those UK red listed birds have been seen most of them regularly, some of them occasionally. I've given you the list on that. A couple of years ago, 2023-24, I did a survey of Matterley and the adjoining farmland, counting nesting skylarks. I did several surveys, and the results of my surveys that were for the adjoining farmland is identical land. It's very, very similar. I mean, you can, but the crops are the same, the land is the same, the altitude is the same, the weather's the same. For every 5 skylarks, I saw nesting on Gander Down and Longwood Warren, which are adjacent to the site. For every 5 I saw on those sites, there was only 1 on Matterley. Just think that through. What's the ecological reason why those birds are not on Matterley, but they are on the adjoining farms? It must be Boomtown. But my review was questioned, let's say, by someone. And so after the last meeting, with help from Cheriton Parish Council, I was allowed to get data from the Hampshire Biodiversity Centre. The Hampshire Biodiversity Information Centre, as I'm sure Zoe will tell you, is run by Hampshire. It's hosted by Hampshire County Council, and it collects data from bird watchers, from people looking at butterflies, from people looking at flora and everything. It is the database for Hampshire, and it is totally neutral. I apologise for you getting late papers. I finished crunching their numbers at 8 o'clock last night. But what you've got on the handout shows that for 4 key red listed birds, the numbers of those birds on the adjoining land was well above the numbers of those birds on Matterley. And now I can go into detail about how I crunched those numbers, but broadly I took the same land areas, about 4.5 square kilometres for Matterley and for the adjoining areas, same length of footpath, because that's important, because that's where people observe birds and therefore put them into the database. And you can see the results in front of you. And my question is, why is the orange line a lot shorter than the blue line? There's a lot fewer of those birds at Matterley. And the only conclusion I can draw is the activity leading up to the festival itself, and the pulling the festival down. The UK government tracks various lists of birds. Again, that data's in front of you, has been for several weeks. 19 farmland birds constitute the government's farmland index. That index has dropped by 61% over the last 50 years.
Oh, sorry, can I be so rude to interrupt you just briefly?
I can't hear you, sorry.
Can I interrupt you just briefly? Could all respondents please bear in mind we have read all the written submissions in full.
Yep.
So while some reiteration is appreciated,
Okay.
and a useful reminder,
Right.
all the information has already been given to us. So you are effectively not making the best use of your time by repeating it to us. Thank you.
I'll cut to the quick. The if the festival is allowed to go ahead, the law will be broken. The Wildlife and Countryside Act will be broken, because I can't believe that 2,000 workers who build the place all get training to spot a skylark nest. I find it difficult finding a skylark nest, and I've been at it for 70 odd years. And that damage will occur to wildlife. And therefore, if you allow this license to go ahead, you will allow the Boomtown people to contravene the Wildlife and Countryside Act. So I thank you for listening and hope that you enjoy the numbers.
Thank you.
Mr. Jones, can you turn your microphone off, please?
Yeah, any questions from my fellow councillors? I have one question. Do you have any direct evidence of specific acts of law breaking or illegal activity that you would can use? Because you made a very compelling case in terms of a correlation between Boomtown and the loss of these birds, which is great concern to us all. But do you have any specific examples of an incident which you would say was against the law?
Unfortunately, Chairman, there's very little opportunity to do that because the only access to Matterley Farm is on the South Downs Way, which I walk very, very regularly. And they take great care when they're doing this construction to keep their machinery away from the South Downs Way so that you can't see what's happening. So no is the direct answer to your question.
So no report has been made to the police, no sort of, you've not called in the police to say that you think there's been a crime committed at any point?
I personally have not done that, no. There is a countryside wildlife officer in the Hampshire Police. She's quite a feisty lady, but no, I have not phoned her to say, and is good at what she does. But no, I have not.
If I can thank you for your submission and answering the questions, I'm sure we'll bring this up
Just
later.
add one point on that. You probably saw beforehand, Peveril Bruce and I shook hands, we talked to each other, we tried to be civil. And we are civil to each other. I hope I'm civil to him. It's certainly civil to me. What I don't want is to go round his farm saying, arrest that man. I want to put my point across in a diplomatic way, as I hope I've done this morning. Thank you.
Thank you, it's appreciated. Okay, if I can go to the next.
Sorry, Mr. Jones, can you turn the microphone off, please?
Thank you, Mr. Jones. If we can have the second other person wishing to make a representation, which is Alison Matthews.
Good morning. I'm here very simply and very briefly as a local resident and a committee member of the Apparition Valley Society to try and ask you to consider the position of local residents for the period of 6 days while this festival is going on, from Wednesday to Sunday, depending on the weather and the way the wind blows. We cannot rely on getting very much sleep. I don't think it's unreasonable to expect to go to sleep by midnight or 11 o'clock, but on the Friday and Saturday, we have to choose in August. It's hot, usually, and we have to choose between having the window open or closing the window and hoping to dim the noise. But where I live in Avington, I cannot really rely on getting very much sleep, certainly on those 2 days and on the earlier ones. And I'm not the only person in this position. And I would ask you how you would feel if you and your families could not rely on a night's sleep from 11 or midnight to the next morning, added to which we have the bass beat thudding away during the day. So we are already feeling somewhat frazzled by the time the night comes. So can I ask you to consider that midnight is time enough? The 4 o'clocks, the 2 4 o'clock nights are really very hard for local residents. That's one aspect of the public nuisance. The other, of course, is the traffic. And the third one is the strobe lighting, although I believe you don't deal with the strobe lighting. The strobe lighting is, do you deal with it?
My understanding is from we have to consider the objectives of the South Downs National Park, which is that there's no environmental harm.
Yeah.
And I would suggest that light pollution could be considered an environmental harm. So I think it would be within our remit. Is that correct?
It can be also a nuisance lighting, so nuisance lighting, for example. So it targetedly does engage your remit in terms of prevention of public nuisance.
Yeah, the strobe lighting does affect us very badly. It also affects drivers on the local roads who are not expecting it. It distracts them. And I've had friends who've been driving on the major road, the main roads, the A roads, who've suffered from suddenly encountering strobe lighting. And of course, they don't know what it is from or where it is or anything. So it's quite dangerous. And it does cover the area again on the Friday and Saturday nights. The traffic disruption on the Monday, when in the Winchester area, is really serious. And I dread to think what it will be like when the work on Junction 9 starts. That's really all I want to say, but I just hope you will think of it from the point of view of the local residents. You are our councillors. And we have to look to you to put timing, noise levels and conditions on our behalf. Thank you.
Thank you very much. And I can assure you that the views of local residents will be taken into consideration with any sort of decision we make. We would not dream of devaluing or dismissing any sort of representation made by a member of the public. Do my councillors for the council have any questions? No.
Just a few questions, just so we can ascertain, obviously, with regards to Mrs. Matthews. Mrs. Matthews, you made reference to a society. Mrs. Matthews? You're appearing today as a personal individual solely, is that correct? You don't have the authorization to speak on behalf of that society?
Sorry, can you approach the microphone again, please, because it's not being recorded.
I do actually have authorisation to speak on behalf of the Upper Itchen Valley Society, but I was told beforehand that it was too late because we hadn't mentioned it in the letter.
That's right. So it's a personal representation from you. It's at page 52, members, we can see Alison Matthews. It's only a personal representation. It's just the inference being drawn in regards to obviously the mention of a society. So just to make sure it's a personal representation. The second point, Mrs. Matthews, page 52, your submission referred to traffic, but yes. I'm afraid your personal letter didn't actually address the issue of traffic, did it not?
I think only briefly. I'm
afraid it didn't.
Oh.
But in that regards, members, I ask you to attach very, very limited weight, if any at all, in relation to traffic to that representation.
Right.
Okay, well, thank you very much for your speaking to us, Alison Matthews. I'll move to the next other person representation, which is Brendan Gibbs, who is representing Titchbourne Parish Council. Thank you.
Good morning, everyone. You will be pleased to hear I don't have very much to say at this moment in time, other than to represent the Parish Council's resolved position. We submitted a representation after Hampshire Constabulary applied for a review of the licence. We commented on the prevention of crime and disorder and public safety. We note the Hampshire Constabulary have now withdrawn their application for review. So our basis for objecting or commenting is on the licensing objective of prevention of public nuisance. I don't want to go in through any more than that document. You have got it in your bundle, and I just make sure that everyone is aware that it's there, and the Parish Council believes that that representation is still valid. Other than that, I don't have anything new to bring to the table. So that's the limit of my comment. I just want to record the fact that Titchbourne Parish Council have asked me to represent them at this meeting, and I've expressed their resolved position to you, and I'm happy to take any questions.
Any questions from my fellow councillors? Just for my own sort of reference, Titchbourne, what would you say with the distance from Boomtown is for your residents?
It depends where. I mean, Titchbourne is a very linear parish. It stretches from the A31 and goes through to Longwood and beyond, through into almost Oswaldbury. So it wraps round the Boomtown area. So at its closest, I would say it's about less than a mile, but it's furthest away. It's almost to the A31 Ladycroft Junction.
So it'd be fair to sort of characterise the fact that the people who live closest to the event are the ones who are most inconvenienced by it, you would say.
Yes.
And the ones who live further away are not making any sort of complaints at all.
The ones who are closest to it, in the hamlet of Sevington, you will find that there's representations from members of the public there who live in Sevington, which is just north of the Cheriton parish boundary.
I guess all my questions. So thank you very much for coming to speak to us.
Thank you.
And now move to David Payne, who I think is initially speaking on behalf of, in a personal capacity on behalf of other residents. Thank you.
Good morning. I'm Councillor David Payne, Vice Chair of Cheriton Parish Council, and I would like to begin by thanking you for allowing me to address you on behalf of the Parish Council. I'll be speaking again on my own account and on behalf of some of the other individual representatives later. Cheriton Parish Council has made a representation on the grounds of the prevention of public nuisance, specifically regarding noise pollution caused by amplified live and recorded music from open air sources. But before I address you about that, I would respectfully like to draw your attention to two other relevant factors relating to this licence. The existing licence does not comply with the City Council's adopted licensing policy, and the amendments in December 2023 to the National Parks and Access to the Countryside Act 1949 by Section 245 of the Levelling Up and Regeneration Act has changed the legal framework, and government guidance about this was published as recently as last month. This review enables the subcommittee to take into account its revised licensing policy adopted in January last year, the amended 1949 Act and last month's government guidance, all of which have been published since the existing licence was granted 5 years ago in 2019. Our full representation is on pages 18 to 23 in your bundle, which I'm sure you've read, but I would now like to take this opportunity to stress some key points. Dealing firstly with the licensing policy, paragraph 1.4, to which the licensing manager referred earlier, states that applicants for premises license should ensure that there is appropriate current planning permission for the hours and activities for which the application is being made. The temporary planning permission expired last month, but as mentioned in agenda item 3, submitted yesterday, I believe, by Mr. Phipps of Boomtown, Boomtown is now attempting to rectify this and has submitted an application on Christmas Eve seeking a further 5 years of permission and to increase the attendance level to 76,000 minus 1, which would bring it into line with the premises licence. This will obviously be considered and determined in due course by the National Park Authority as the planning authority, but I would like to draw your attention to one key fact which is in the planning statement mentioned by Mr. Phipps. Boomtown want to increase the number of public ticket holders from 48,000 to 63,000, which is an increase of 31%. But they also want to reduce the number of crew from 18,000 to 13,000, which is a reduction of 28%. The crew includes people engaged in the safety of the public ticket holders, including those responsible for drug searches, and this could be a matter of interest in respect of the public safety licensing objective. This indicates the importance of appropriate planning permission being in place before a licence is applied for. The Parish Council would also like you to consider the important matter of the amendments to the 1949 Act of Parliament, which strengthen the duty of relevant authorities when making decisions about land in a national park. The City Council is now required in law to seek to further the South Downs National Park purposes, and this was also mentioned by your licensing manager. Furthermore, since the original hearing was adjourned on the 25th of November, and as your officer's report makes clear in paragraph 4.9, The government has now issued guidance for relevant authorities, such as this one, on seeking to further the purposes of protected landscapes. This is an active duty and not a passive duty, as your licensing manager's report mentions. And I'm sure you would take this fully into account when considering if the premises licence should be revoked. Your officer's report correctly defines the two statutory purposes of the South Downs National Park. Purpose 1 is about conservation and purpose 2 is about enjoyment of the park. Where there is a conflict between the two, as in this case, purpose 1, conservation, must have priority. Allowing a major music festival to take place in a national park is an example of purpose 2. But in the opinion of the South Downs National Park Authority, the festival does not comply with purpose 1 because it does not conserve and enhance the natural beauty and wildlife of the area. And this was made clear by the Director of Planning for the National Park Authority, Mr. Tim Slaney, and this is a matter of public record and is to be found on their planning website. Boomtown submitted a planning application in January 2021, seeking permanent permission to replace the extant temporary permission and to increase the attendance limit by 11,000 to bring it into line with this licence. The National Park Authority had the application under consideration for a very long time, and in fact it was not until the beginning of December 2022, over 22 months after they had received the application, that it was included in the agenda for their planning committee meeting, which was to be held on the 8th of December 2022. The committee report by Mr. Tim Slaney, Director of Planning, recommended the committee to refuse the application. My parish council did submit to the council the full SDNPA committee report to your licensing manager for your convenience, but it has not been included in the bundle. She did, however, kindly inform me that I could refer to it today. I do have some copies of the relevant page.
Councillor Payne, you've submitted late evidence already, which is causing adjournment at the start of the hearing. And now in your representation, you're trying to, again, admit late evidence. So in this regard, you're going to have to let me see it beforehand. We'll adjourn again. I'll talk to my learned friend about whether or not his client is ready to admit it. It's a matter for you, or
No.
I pause you here. What you say next, say very carefully. Because if you're omitting evidence, I'm sure Mr. Phipps might take umbrage with that, and we'll make representations.
Right. On page 22 of the bundle,
Thank you.
which is the original written representation by the parish council, you will see that 3 reasons are there, which were given by the Director of Planning in his committee report. Reason 1 includes this statement. It is not therefore considered that the proposal would conserve or enhance the natural beauty and wildlife of the national park, and the proposals would therefore not comply with the purposes of the national park. And reason 2 includes this statement. The proposals would therefore not comply with the purposes of the park. So the Director of Planning for the South Downs National Park Authority, who we think must be considered an expert on what does and does not comply with the national park's statutory purposes, concluded after long and careful consideration that the natural beauty and wildlife of the national park would not be conserved and enhanced, and that the music festival does not comply with the purposes of the park. These purposes are still the same today, and we believe the Director's comments remain valid. A few days after Mr. Slaney's committee report was published, the applicants withdrew the application, and the case was removed from the committee's agenda and no determination was made. As purpose 1, conservation, must have priority over purpose 2, enjoyment, the parish council believes that the considered opinion of the National Parks Director of Planning provides a sound reason why you should consider revoking the licence today. However, if you find reasons, valid reasons not to revoke the licence, we request that you take this opportunity, which is the first since 2019, to curtail the level of disturbance caused by amplified music to further the licensing objective for the prevention of public nuisance. Noise nuisance has been caused to residents in our parish and other parishes during Boomtown music festivals for several years by amplified live and recorded music. This is allowed by the current licence to take place until midnight on Thursdays and Sundays, but worse, it is allowed until 4 AM on Friday nights and Saturday nights. Residents in their own homes with all windows closed and the benefit of double glazing have been prevented from getting to sleep or have even been woken up during the night, particularly by low frequency bass noise which travels for miles. Evidence of this has been provided in a number of the individual representations, and Mrs. Matthews spoke before me and she mentioned this as well. Our parish is in the South Downs National Park, and one of the special qualities of the park is relative tranquility. The adopted South Downs local plan contains a tranquility scores map for the whole park. This shows clearly that Cheriton and other villages which surround the festival site are scored as intermediate or high tranquility. Cheriton Parish Council now has evidence to prove this. We engaged a reputable acoustics consultancy, Sustainable Acoustics of Lower Upham, to undertake noise monitoring at first floor bedroom height in 2 positions in the parish, both before and during last August's event. The recorded ambient noise level during the nighttime hours after 11 PM prior to the festival starting was as low as 18 decibels. The consultancy has advised us that the sound measurement scale is logarithmic and not linear, and a music noise level of just 10 decibels above the ambient, which is 28 decibels, would be twice the perceived loudness, and 20 decibels above the ambient, 38 decibels, would be 4 times the perceived loudness. However, after 11 PM, the licence allows a music noise level of 45 decibels, and this is monitored by mobile teams at a height of only 1.5 metres above ground level. And we are advised that this can result in noise levels different from those at first floor bedroom height. We consider 45 decibels is too high, but acoustics is a complicated matter, and we do not offer an opinion on what a more appropriate number of decibels should be. Therefore, if you decide not to revoke the existing licence, the Parish Council requests that you should enable your fellow residents within Winchester District who reside in the National Park to be able to enjoy a decent night's sleep. You can do this in a simple, easily understood way by amending the terminal hours relating to live and recorded music. We respectfully request that you amend the terminal hour to be midnight on all nights of the festival. This would redress what we believe is the imbalance between the commercial interests of the licence holders and the rights of local residents to be able to sleep peacefully in their own beds. This would also be in accordance with your licensing policy, section C2, which states, quote, stricter conditions with regard to noise control will be expected in some circumstances. This includes subparagraph 2, areas of the district that have low levels of background noise, such as within the South Downs National Park. Subparagraph 3, licensable activities which extend into nighttime hours, e.g. 2300 to 0700. And subparagraph 4, licensable activities to be held outdoors. We do not believe that at present there are any stricter conditions with regard to noise control in the licence, given that the site is within the National Park, the festival extends into nighttime hours after 2300, and the noise sources are outdoors. Helpfully, the supplementary agenda evidence from the licence holders in Appendix 6A in your bundle shows that at Glastonbury and the Isle of Wight festivals, neither of which is in a national park, the primary outdoor stages and arenas, respectively, are shut down at midnight. But large stages at Boomtown on Friday and Saturday nights continue until 0300 and 0400. These are on pages 155 and 163 in your bundle. I don't know if you'd like to look at those. Page 155 to start with.
Thank you. I'd like to remind you again that we have read all your submissions and you are reiterating information which is already very familiar to us. Can I ask you, you're down here to speak on behalf of a number of other residents.
Yes, if I could do that shortly.
You will be making the same points again, or do you think you'll be making additional points to those you've already made?
Similar.
Similar. Can I ask you to sort of, if possible, to sort of combine them so that we get the greatest effect from your submission rather than you having to go through the effort of repeating yourself to us. Thank you.
Okay.
Chair, if I may, as well, before you continue, Councillor Payne, you're referring to now page 155, I believe, of the bundle, is that correct?
Correct.
This was the supplementary papers to the original agenda pack, correct?
Yes.
Did your parish council submit the representation before that supplementary paper was actually produced?
No, it didn't.
I've been told by the licensing manager that the parish council did indeed submit the representation prior to that supplementary pack.
Sorry.
The point is, if you cannot speak to that particular document because the parish council authorised at the particular point in time for you to speak.
Right.
If this document came after your parish council resolution, it's a personal submission and not the submission of the parish council.
Right. Yeah, thank you. Yes, I'll pass over that point then. In conclusion, what we would request you to do is to change all references to 0400 in the licence to 0000, which is midnight. And in summary, appropriate planning permission does not exist. Some parts of your licensing policy are not being complied with. Section 245 of LURA 2023 and recent government guidance require you to seek to further the purposes of the South Downs National Park and to give priority to conservation over enjoyment. And the considered opinion of the National Park Authority's Director of Planning is that this event does not comply with the National Park's purposes, and these are factors that you are asked to consider when deciding if the licence should be revoked. However, if you decide not to revoke the licence, we request that you impose stricter conditions on noise control as required by your licensing policy and amend the terminal hour for amplified live and recording music to midnight on all nights. Thank you very much.
Thank you. I have a number of questions to my fellow councillors. Any questions first? You're speaking on behalf of Cheriton. Yes, you're Cheriton Parish Council, and that's an area of, as you mentioned in your submission, high tranquility.
Yes.
Yes. So would you agree with me that people who live in an area of high tranquility are more likely to notice noise than those who live in a city or a town who are used to a constant level of background-based noise anyway?
Well, I'm afraid that wasn't considered by my parish council, and in view of what Mr. Lucas has said, I'm unable to answer the question.
Probably better placed to Mr. Payne in his capacity as a personal individual.
Okay, I might repeat that question when you have we can move to your personal capacity. Thank you. And can I ask for some environmental guidance on what level of noise you would say that 45 decibels? Is there something we could use as an everyday comparison for something that would make that level of noise?
It's quite difficult to actually explain in terms of what sort of level of noise that would be subjectively. that level of noise is based on the World Health Organization guidelines for prevention of sleep disturbance. So
Sorry,
it
I
would
didn't
be
hear
the
that.
15 to 45 dB. The 15 decibels probably taken from windows would make it roughly 30 in properties, and that's where that originally came from, that condition.
So would that would be greater than people would expect living in a normal built-up area?
Background levels can vary quite considerably, so you would have to do a proper background survey to check whether or not the background levels are representative. And of course, we've got quite a number of different areas surrounding the site. So we'll have the Winchester, which you'd expect to have a slightly higher background. Places like Cheriton, yes, would have a lower background level, but I'm not quite sure about the 18 decibels. I haven't seen any report with the gratify.
Thank you. You mentioned it's very subjective, which I think is because what anyone's used to, you can become more susceptible or more noticeable to noise.
Yeah.
My last question is,
Sorry, just to add a little bit there, that there is a difference between the steady state noise, like this 45 dB, the LAEQ, steady state noise, and the bass noise. And bass noise can be, it's intermittent and a bit more discernible. So for me, the bass noise is the thing that I'm more concerned about.
okay, and as just as another point of comparison, would you say that heavy rain or a thunderstorm was the sort of equivalent level of noise? Because that would be something that people in this tranquil area would experience anyway. So whether it's comparable to that.
Yeah, it could mask noise. It could mask noise that's happening in the community. The other aspect is traffic noise. Road traffic noise can play quite a considerable part in the background as well.
Would you like to ask a question, Councillor Laming?
Yeah, thank you. Where do we actually monitor the noise level? How far from the site are you looking at? Because obviously we need to understand that.
So we have 9 monitoring locations which are agreed each year with Boomtown through their licence, through their noise management plan. Those have been carefully chosen over a number of years, right dating back to Homelands, to be representative community areas. And they are changed and tweaked each year because there are certain locations where we can't monitor, for example, on the A31, because there's too much interference with road traffic noise to be able to discern that it's definitely music noise. So they are very carefully chosen, and they are slightly different distances, but they're meant to be representative of local communities.
On that point, members, in your bundle at page 154, there's a helpful plan, the map there, which shows the locations, the representations, the event sites, and indeed the monitoring positions for 2024.
I've got a question for David Payne. I don't know if it's admissible, but if it isn't, you can please scream and stop me. Would you say that characterises the residents of Cheriton? I mean, one of the great selling points of the South Downs is its tranquility and its closeness to nature, clear skies, clean air and so on. Would you say that the sort of people who live there tend to be the people who appreciate silence and tranquility more? And that's one of the reasons why they've chosen to live there?
I'm sorry, I can't possibly answer that.
Councillor Payne, you can. You're the Vice Chair of the Parish Council. The question is about your parish fabric, the environs and the makeup of the parish.
Well, people choose to live in Cheriton for a number of reasons. One, it's got a primary school, which has got a good reputation. It's got good traffic links to Winchester. You can get to London if you're not working from home, of course. It's got nice housing, a variety of housing. It's like many other villages. I don't think people particularly choose to live in Cheriton because it's in the South Downs National Park, but it's regarded as a sort of bonus, if that helps.
I think I understand you're coming from, because most of the reasons you've given for living there are reasons for living in other parts of Winchester and the district as well, because lots of parts of the district have good schools, good housing, good transport links to Winchester. So the difference with this area is the bonus that you are living in the South Downs National Park with all the lovely amenities that has to offer.
Yes, well, my late wife and I chose to live in Cheriton 20 years ago when we moved from South Wales. And And of course, the national park was only created in 2010, 5 years later. So we chose to live in Cheriton for a variety of reasons, which I won't bore you with. And when the South Downs National Park was created, we thought that this would be an additional bonus because it should be more difficult for developments to take place, for example, and but none of the other factors have altered.
Thank you. I appreciate your answers. You are down now to speak not in your capacity as the parish council leader, but in a personal capacity, I think. So
Yes, if I could just get my papers for that.
Absolutely, thank you.
Thank you. Yes, I'm speaking on as an individual and on behalf of Michael Beer, whose representation is on pages 16 and 17 of your bundle. Mrs. Newson, page 24. Mine is on 25 and 26. John Sylvester, 28 and pages 28 and 29. Graham Tarbuck, page 30. Mr. and Mrs. Kerwin Bryant, pages 32 and 33. Michael Curtis, page 34. Alan Wetman, page 35. And Francis Warwick, page 36. The points we made generally cover a few common threads, which are very similar to those that I've just referred to on behalf of the Parish Council. Planning permission doesn't exist. The licensing policy is not being complied with. And the amendments to the 1949 National Parks Act require you to seek to further the purposes of the park. And the Director of Planning for the park said he did not believe that it conserved and enhanced the natural beauty and wildlife, and therefore does not comply with the purposes of the National Park. And we requested that the licence should be considered for revocation. But if you decided not to do that, then we requested that the terminal hour for live and recorded music on Friday nights and Saturday nights should be changed from 4 AM to midnight. Thank you very much.
Thank you. I have some questions, and I also wanted to know, I think in your early submission you mentioned 18,000 crew members for the event. I think that's probably a slip of the tongue, because that seems like an erroneously large figure, I think, for an event of Boomtown size. But anyway, do my fellow councillors have questions first in a personal capacity? Okay, I'll repeat my earlier question in a personal capacity. Would you say that you were the sort of person who, if you are on holiday and in a hotel next to a building site, that you would find that you're more susceptible to noise than a sort of an average person in the member of the public?
Sorry, would you mind repeating that?
I would, given that you live in an area of high tranquility, so that you're used to very, very quiet nights and being able to sleep with your window open on a hot night, would you say that you're more likely to notice noise than someone who lives in a town or a city where that's part of the normal background?
Well, I'm not sure that it's normal for loud thudding bass noise music to be played until 4 AM wherever you lived. And I don't see really how living in an area of relative tranquility alters that.
Well, one of the things I think we need to weigh up is the benefits to the people who attend the festival, as well as the situation of the residents.
Yes, certainly.
And certainly, I would be very aware that many of the people attending the festival will be people who would not normally be able to enjoy the levels of tranquility that the people of Cheriton or members of the South Down Parks enjoy. Would that be fair to say?
Well, obviously it's a good product because a lot of people like to go to it. We just believe that it's being held in the wrong part of the country because it shouldn't be in a national park, in our opinion.
Thank you. Do you have any further questions? Okay, thank you very much for your points and for the briefness of your second point. Thank you very much. I think that completes our representations from other persons. So it is now the opportunity for the premises licence holder to address the subcommittee. Thank you.
So thank you. I'm happy to be guided by you. I'm happy to, if you forgive the phrase, pin my ears back and give you my presentation. But would you like a 5-minute comfort break, or would it be appropriate to have one?
I will have a 5-minute break then, yes. Okay, thank you very much. Welcome back. Well, now it's the time for the licence holders' opportunity to speak to the committee. Thank you. Can I ask firstly, turn on the microphone, and also people have asked if you could make sure the microphone is close to your face so that it's picked up by everyone in the room and also by the recording for subtitles later. Thank you.
Is that better? Thank you. So there is in your supplementary papers at the back of the main agenda a written submission, which I'm sorry to tell you runs to 5 pages of A4, for which I apologise. My proposal, if you're happy, is I am going to canter you through that document. I hope you will all be relieved to know I'm not planning on reading it out. I know you've read the papers and I'm grateful for that. Then I want to just touch on some of the comments within the report itself from your officer. I'll then look at the representations. I'm going to focus on the representatives who've spoken today and the documents that have been produced this morning. I hope, in line with Mr. Payne representing a number of other representatives, that my comments can be taken as attaching to the representations as a whole, and that will be me. I hope that sounds a decent structure. So in terms of the supplementary agenda, sorry, I get this right.
But you have a page reference for this.
Forgive me, it's page 3, but it's not page 3 of the main agenda. It's the supplementary document, a little thin one. Yes, thank you, Councillor Langford Smith. I see. So thank you very much. So what I propose to do, as I say, is I'm going to canter you through this. If at any point you feel that I'm going a little bit too quickly, please just interrupt me. I appreciate there's an opportunity for questions at the end, but just interrupt me as you go if you want something. So first of all, I just attach commentary about the materials that have been produced by Boomtown in respect of the review. The first is a statement from Adrian Coombs. You'll find that on page 179 of the main agenda papers. I'm not asking you to turn to that just at the moment, although I will come to that in due course. But that sets out the engagement that we have with Hampshire Constabulary and significantly attends to, and I appreciate the application's been withdrawn and we're sort of the elephant in the room, if I can almost call it that, is over there, but it does attend to the engagement, dialogue and discussion that we have with the police. And you will see, I think the penultimate paragraph of that statement specifically attends to the engagement that we have had and candidly enjoyed with the constabulary since the decision was made to withdraw the application. And it was referenced earlier on today, and I think when your licensing manager read out the reasons given for the withdrawal of the application, was that dialogue and discussion would be requested and would continue. That is ongoing and has been very positive thus far. I appreciate that slightly to the side of the issues at hand this morning, but important that you hear that from me. The second, sir, is a statement of Mr. Kevin Instance. That's at page 182. Again, I don't need you to turn to it. That provides some significant detail about our crime management policies and procedures. Mr. Instance is on line here today. I don't need to take you through that line by line. I know you'll have given that some regard, but it does attach to a number of the crime management issues that we must attend to as the responsible festival organiser. There is then an event management plan index, that's page 187. That actually runs to, I think, 11 pages, and that's just the index and the list of appendices of all the documents that go into the organisation of an event such as ours. It's a well recognised approach to the safe and careful management of large scale events throughout England and Wales, and candidly further afield as well. I do make the perhaps obvious point that lots of the issues that have been touched on in the representations, noise as an example, traffic as an example, but it covers a wide miscellany of issues, are all set out there as obligatory policies to be produced and shared with all of the officers. And it is not the responsible authorities just, without denigrating them, that we are talking about. It's the whole safety advisory group that is effectively hosted by Winchester City Council, which includes officers outside of the responsible authorities, such as the ambulance service, the highways officers, as an example. There is then at 198 a commentary on the representations from Robert Miller from F1 Acoustics, who are our noise acoustic consultants. Mr. Miller is online and can answer questions if I can't, but he provides some comment on the issues of noise, and I will turn to that in due course. For the avoidance of doubt, we have a noise management plan that must be drawn up and shared with all of the relevant officers. That plan has monitoring as a significant feature of it, the delivery of the levels that are set out in the licence as specific conditions. The monitoring points, as your environmental health services manager explained, are amended from time to time as circumstances and knowledge changes. And there is nothing about the presentation that I will be giving you this morning to suggest that those are fixed and that those cannot be considered in light of the representations and the no doubt ongoing dialogue that we'll be having with your environmental health officers. I should say, and it's true of the Safety Advisory Group officers as a whole, the dialogue is year round in all reality. Of course, it ramps up in the run up to the event itself, but there are debrief discussions, there are individual meetings about particular topics that particular officers would have issues and I'm bound to make the point that the engaged, transparent process, which will involve dozens of meetings and I suspect hundreds of emails and probably more messages besides, telephone calls, Teams calls, Zoom calls, whatever, is a point of significance with regard particularly to the absence of any officer representation before you today. None of the responsible authorities have served representations, but none of the other officers, all perfectly entitled to serve representations. And that might, for example, include the Environment Agency when we come on to look at the suggestion that we are intentionally forgiving.
Sorry, can I interrupt you on that point? I just need to check whether other representations, did they have the opportunity to be made? Because this is an adjourned meeting where the original meeting was about crime, and so there wouldn't have been representations made at that meeting either.
So the Licensing Act 2003 requires all applications to be consulted. All responsible authorities are considered on all of the applications, bar minor variation if it is not relevant to their area of expertise. So all responsible authorities received a copy of the police's application, albeit I take your point that it refers to crime itself, but they should all be aware under the legislation that that allows them to effectively piggyback off the back of the police's application and make a representation if they have concerns about the promotion of licensing objectives, like the local residents did.
My concern on this point is just whether the absence of them making a representation is being interpreted as tacit approval, or I don't think we should make that inference, should we?
A point in cases the South Downs National Park Authority, they contact us with comments to say that they supported the police's application, which was referenced in the previous report. However, when we went back to them and said, are you making a representation? We cannot accept comments. You have to make your comments that are relevant to the 4 licensing objectives. They acknowledged that and they said we have no representation to make. So I would expect us, certainly after this number of years that we've had this legislation, that each responsible authority should understand their role within the legislation that says, even if it's not about crime, which is what the police put forward in the application, you can submit a representation at this point if you wish to.
Thank you. Sorry for interrupting.
But do you mind if I just make the point about tacit consent? I do say that to you. If you don't serve a representation as a responsible authority, you are saying, I have no concerns to raise to the licensing committee, full in the knowledge that the matter in due course will be proceeding to be considered by the committee. I say that unashamedly. And I say that that extends not just to the responsible authorities, but all of the other officers that may have chosen and have chosen not to, but may have chosen to bring concerns about any issue that they would have concerns about, whether that was specifically within their remit or any other concerns. I do say it's probably respectfully stronger than tacit. Anyway, there is then just a little document produced also by Mr. Miller, who has some knowledge about the Glastonbury Festival, just to make the point that some of the commentary in the representations about Glastonbury finishing at midnight or having something, the appearance of being more restrictive than Boomtown, or Boomtown being in some way being seen to be more generous in its licensing terms than Glastonbury, is respectfully wrong. And then we also have some commentary from Boomtown about ecology. I just address you on the issue of ecology, and that's on page 176 when you come to it. But I'll just address you on the issue of ecology, if I may. Ecology is not a licensing objective, and as you indicated at the very start of the proceedings, Chair, we are concerned today with the licensing objectives, of which ecology is not one. But
can I interrupt you there? I think one of our objectives is to observe the objectives of the South Downs National Park, and the conservation of wildlife does fall into that remit. Is that correct? So can I take guidance from legal advice?
You have to have due regard to the duty that we've spoken about. So the access to the countryside duty, you have to have due regard to it. That's something that you take away, as I've mentioned before, and you factor it into your decision. Mr. Phipps is correct in that it's not one of the 4 Licensing Act objectives, but there is the wider duty to have due regard to the access to the countryside. So nothing that Mr. Phipps is incorrect in that regard. No.
We have a wider duty to consider the objectives of the South Downs National Park as well.
Indeed we do. Indeed we do. Then that's been referenced in the officer report. So you have that particular duty outlined in the officer reports. So do refer to that report. And when we come to retire, we can consider obviously those particular points when you make your final decision. But in relation to the Licensing Act objectives, those objectives are the 4 objectives that we are very familiar with.
Thank you. And sorry, but you did say it'd be okay to interrupt. So I took that as permission.
So my point just here in terms of ecology is not actually the South Downs National Park purposes point, which I'll come to. The point is simply this, that Mr. Jones in his representations, his documents and his additional materials seeks to suggest that the premises is damaging wildlife. And he's to generously, if I can call it that, quite properly said in his representation to you that that's not a licensing objective. That may be a matter for planning, that may be a matter for other legislation. But what he said to you was, unless a crime is committed, and then the crime and disorder licensing objective is engaged, which is entirely right, and there's nothing to argue with. And what he says in his representation is that we are intentionally killing birds. That's what he's saying. Be under no illusion about that. That's expressly the conclusion that he is inviting you to draw. And I think
again, I'd interrupt you. I think it was I think his point was it was an inadvertent part of your event. It was not that you go out there with guns and you go, who can kill the most sparrows. I think it's an inadvertent byproduct of your event.
Yes, but you forgive me, I appreciate this. I'm not here to challenge you, but if Mr. Jones says it's inadvertent, then it can't be intentional, and therefore the entire representation falls. I, to be fair to Mr. Jones, did not hear the word inadvertent. If Mr. Jones said inadvertent, I'll say no more about it because it doesn't need to detain us for another second. I didn't hear inadvertent. I heard intentional.
Chair, we're running into territory which is about hypotheticals and semantics here. The crime is to intentionally. Now, the definition of intention is in the realms of criminal law. We don't need to understand or go into the minutiae of what is meant by intention. But Mr. Phipps has probably accurately described the thrust of Mr. Jones's representation, and that is that Boomtown are intentionally killing ground nesting birds. In that regard, it's right for Mr. Phipps to address that particular point. Obviously, he has to respond to the case put by Mr. Jones in this sense. So,
yeah, can we proceed on the basis that that was the meaning of the point made, so that you can rebut that point if that was on the basis that that was the point made? But
and all then that the document at 176 sets out is a brief explanation of the enormous investment that Boomtown make toward ensuring that they don't do that, and indeed that there is enhancement, mitigation and improvement. And the suggestion that we are intentionally killing birds is to some extent attended to within that document on page 176. Because just to be very clear, if it isn't, we do not intentionally kill birds. Let's just be clear about that right now. In terms of the, just over the page onto page 4, I am not proposing, sir, to address you on the issue of the police application and their request for 2 conditions, because the application has been withdrawn. They're no longer parties to the proceedings. But there are 2 ancillary points that I'll make, if I may. The first is that the police application itself simply sought 2 additional conditions. You heard from your licensing manager, you can choose to take no action. You can modify the license by attaching or amending conditions. You can suspend the license, you can revoke the license. And I say that the point about the police only ever in the first place seeking to attach 2 conditions is something to reflect on when you hear the representations of the 17 representors who seek revocation of the license. And if you take time with their representations to go through them, they seek revocation of the license because of points about planning permission, about the South Downs National Park, and about the licensing policy commentary about planning, which I respectfully submit to you, it is clear, have nothing to do with the licensing objectives. By their own admission, they are issues unrelated to the 4 licensing objectives in and of themselves. So I say that the request for revocation alone is perhaps instructive as to the nature of the representations and candidly the representors.
Again, I have the opportunity to interrupt there. Having read them, my interpretation was that they listed that as a number of options of being, if we can't get this, then we'd like that. And so it was not necessarily that they're all saying that they want the license revoked totally.
I entirely accept that point. My point is slightly different to that. So a number of the representations are the same. They have copied paragraphs between themselves, particularly about the South Downs National Park, particularly about the planning and a number of the other issues. The order in which the representations are drafted and the order in which Mr. Payne presented his submissions to you today was this: planning permission has lapsed. South Downs National Park purposes are not satisfied by an event such as Boomtown. Therefore, you should revoke the license. If you're not minded to revoke the license, we'd like to raise public nuisance and other issues with you, and you should reduce the hours. So the revocation is not, if one goes through the representations, it is not because of the totality of the concerns. The revocation is pitched in all of the representations as being a reasonable conclusion from the lack of the planning permission and the perceived, alleged failure to deliver to the purposes of the South Downs National Park. So I merely give it to you as I say that it is instructive as to the nature of the points that are made. For what it's worth.
I think we can make our own weight on how instructive that is.
So then, sir, if I might, then the point about the licensing objectives, I've made partway down paragraph 4, but just to be very clear in terms of the legalities of it, it's paragraph 11.9 of the National Guidance for the benefit of your legal advisor. Representations must be relevant, I relate to one or more of the licensing objectives, and your own policy says that a representation is considered relevant. It must relate to the likely effect of the grant of the license on the promotion of at least one of the licensing objectives, and that context must frame the consideration, as I'll now turn to, of the issue of planning permission. So you have heard that your policy sets out that it's advised that planning should be in place before a licensing application is made, and we accept that. But it's also right, paragraph 1.8, that your licensing policy states the council recognises there should be a clear separation of the planning and licensing systems, and licensing applications will be viewed independently of planning applications. The licensing application is not a rerun of the licensing application, should not cut across planning decisions, so forth. So what we say is that the position here is not analogous to the initial paragraph. We're not making an application. We haven't made an application. What we entirely accept is that for our event, with the time it takes to set up and the time it takes to break down, which extends beyond the licensable activities that are the subject of the license, we will need a planning permission. Planning permission application has been made. I'll come on to touch on that in a moment. But that's no part of today's deliberations, respectfully. That's no part of today's deliberations. That's deliberation for the South Downs National Park in due course when they come to consider it. And so I say that the absence of a planning permission or the submission of a new application for planning is of no material concern today and is of no material consideration to the licensing objectives themselves at all. And in terms of the latter point, I'm not sure anybody has suggested that it is, to be fair. And it's a passing point, but the South Downs National Park would have been perfectly entitled to have made a representation themselves. They're a party to a licensing proceeding. They've chosen not to. You've got my earlier comments about the significance of that. The second point about planning, which touches on the new document that was produced by Mr. Payne today, is that in 2020, an officer recommended the application that was then before the South Downs National Park, that it should be refused. I accept that. But the degree to which that's relevant will be a matter for you to consider, but I say it's candidly irrelevant. I cannot see that it has any relevance. It was 5 years ago. It was an application made to a completely different authority about a completely different legislation. But the significant point that I'd also invite your attention toward is that many of the representations, I think Mr. Payne himself said this morning, nothing has changed. Well, that's just plain wrong, because we've had a number of other festivals since the withdrawal of the previous application. And bear in mind, it was an officer's recommendation. For all we know, South Downs National Park may have chosen to grant it. Not all applications are refused when officers recommend refusal. Not all applications are approved when officers recommend approval. And the reason that the additional events are of particular significance is if one turns to the document from Mr. Payne and looks at paragraph 1, sir, it's the slip of paper that looks like this. What the document actually says is this: it has not been demonstrated, in the absence of sufficient ecological evidence gathered over a meaningful period covering a number of festivals. So the representations, and it is fair to say not the Cheriton Parish Council, because they fully quote the comments, and this criticism is not levelled at them in any way, because they gave a very fair account of what the officer recommended. But the bulk of the representations say that he recommended refusal without referencing the fact, as I read it and as I submit it to you, that this recommendation can fairly be read as saying, go away and get the evidence, you haven't got it now. And that is how I read, in the absence of sufficient ecological evidence gathered over a meaningful period covering a number of festivals. And we say unashamedly, and I know that this is about planning, which I'm the first to say is irrelevant, that's what we have gone and done. And our planning application that is now before the planning authority provides very comprehensive materials to do what we were requested to do by the officer 5 years ago. The next point, if I might make, which starts at the top of page 6 of the supplementary agenda, is the national park purposes. You must have regard to the purposes, and that is entirely accepted. Absolutely, you must. And the way in which the policy sets it out is that the licensing authority will seek to further the purposes when considering applications to ensure that they are respected. And I'm entirely content that you give that the appropriate regard. What we simply don't accept nor candidly understand is how it is suggested that we do not satisfy the purposes. We deliver to the purposes. You're told almost as a matter of fact that the existence of Boomtown in some way undermines or conflicts with the purposes. And I'm afraid that is a point that we're lost to understand. And if I could jump to halfway across page 7.
So if I can interrupt you on that point, you are putting forward the case that Boomtown conserves and enhances the objectives of the South Downs National Park, and it improves the environment by taking place.
Get the microphones on, please.
Sorry. Yes, that we conserve and enhance the natural beauty, wildlife and cultural heritage of the area, and that we promote opportunities for the understanding and enjoyment of the special qualities of the national park by the public. Yes, I do. And could I, if that's, I don't know if that sounds wrong to you, but halfway through page 7, and it is set out at paragraph 1.6 of your licensing policy. You have a link in your licensing policy at paragraph 1.6 to the guidance that is issued by the South Downs National Park for organisers of large-scale festivals and events. And if you follow through that link within your own guidance, the introductory page says, the South Downs National Park Authority wishes to work positively with organisers planning large-scale events, such as festivals and sporting events, within or close to the boundary of the national park to ensure that events are managed successfully. So, candidly, and I make the point bluntly, if the existence of a festival wouldn't promote Purpose 1, the South Downs National Park Authority themselves couldn't be promoting large-scale events within their confines. It respectfully seems to me as night follows day, that if the South Downs National Park said you couldn't promote Purpose 1 if you were a large-scale festival, the guidance would say, we don't allow large-scale festivals, and that's the end of it, because you can't satisfy Purpose 1.
On that point, it's just my natural scepticism
I know, and
about a music festival.
I
can understand you can justify it on the basis of having no harm to the environment, but the idea that it actually enhances the environment and that the net result of Boomtown is an improvement to the South Downs Park, I think is possibly, you might be overreaching
No.
yourself there.
Chair, if I may, I think we're in the stage where Mr. Phipps is making representation on behalf of his client, Boomtown. If we look at the procedure, the time for questions will be after the representation. So I think otherwise we will be forever in a toing and froing. So I think Mr. Phipps needs to finish his submissions. And then if we have any questions, if you look at number 17, the subcommittee may ask questions of the premises license holder.
I'll stop
Otherwise, we're in
interrupting.
a rapport which is not intended to be.
I'll stop interrupting quite soon. I'm saying.
But to be fair, I did invite it because it always seems to me as points arise. Thank you, but don't feel the need to do it on my behalf, I suppose, is the. Well, sir, the natural scepticism point, I get, and I appreciate that. So can I then just take you, and I'm afraid that because you've said the word scepticism, I'm going to take you through this in a little bit of detail. Could I just invite your attention to halfway down page 6 of my additional submissions? So what I think is the 5th paragraph, the planning statement that accompanies the existing planning application runs to 88 pages. I hope everyone will be pleased that I have not incorporated that within the papers, but that forms a suite of papers that support the planning application, which includes design and access statement, heritage statement, ecosystem statement, ecological mitigation and management plan, information for habitats regulations assessment, outlined biodiversity gain plan, and a statement of community engagement. And then if we go through the extracts of that, which I've effectively quoted, and I'm mindful of what I said about cantering. 2.3, time has allowed us to gather the ecological evidence. 6.11, no lasting significance, wider use of the land consistent with the statutory purposes. 6.14, variety of conservation and landscape enhancements are proposed. Conservation and long-term enhancement of the natural beauty and wildlife further on down 6.14. Cultural heritage is preserved. That's of course one of the key considerations in purpose 1, and sustained, enriched by large numbers attending. There can't really be any challenge to purpose 2, even respectfully any scepticism, because we bring significant volumes of people to enjoy the national park. We're delivering to the duty to foster economic and social well-being. The expenditure issues are attended to with 17 million for each event, and that goes directly to the issue of duty about economic support. So whilst I'm very respectful of the scepticism, perhaps scepticism, it'd be fair to say the representors share. My point in simple terms is we don't accept that, we say otherwise. And then, I hope not indelicately, what I say is that whether I'm right or wrong, and I'm not wanting to imply I'm wrong by saying that, but whether I'm right or wrong, that's a matter for the South Downs National Park when they come to consider the planning issue. Licensing committees have to ensure that the purposes are respected. And what I say unashamedly, an application for review, not an application that we have brought, where we are effectively inviting the status quo, and where there is no officer engagement from anyone, let alone the South Downs National Park, it is impossible for this committee, respectfully, to conclude that the purposes are being undermined such that it would impact your decision. That's, I hope, a fair summary of my point. In terms of the next points from the planning statement, again, I just will take you through a little bit of the points about skylarks, particularly. It could equally be said to be barn owls. Just within the planning statement, there was an explanation as to some of the work. The planning statement is effectively a summary of all of the other policies that I've referred to above. We have skylark plots provided, we have monitoring of plots, we have locations being confirmed within our policies. We're already in discussions with Hampshire and Isle of Wight Wildlife Trust. We install bird boxes and so forth. And so the very suggestion that we are intentionally killing skylarks, which is the only way in which this issue is of particular grip from Mr. Jones's representation cannot fairly be said to be evidenced before you today at all. And in passing, I should say, barn owls are covered in equal detail in the planning statement that I've quoted you. That's a modest extract, I'm bound to say. There are pages and pages of materials, and indeed there are, if not a dozen reports, certainly 10 or so reports, many of which attend to issues of what I have called ecology, but for our purposes, which attend to conserving and enhancing the natural beauty, wildlife and cultural heritage of the area. And so we do say, I'm afraid, without any embarrassment, we deliver to that purpose as well as the second purpose. In the context then of revocation, well, I've covered revocation. In the representations, those 2 points invite the representors to suggest that revocation is appropriate. I've covered that really. Then there's the issue of public nuisance. So the first point to say is we have an impact on the local community through the nature of this event. You are Winchester councillors, you will know that. Traffic will be slower. There will be more people around. There will be inevitable impact as a result of an event of this size, as there would be for any event of this size anywhere in England and Wales. Impact, however, irritation by some, it is not respectfully public nuisance. Are we committing public nuisance in the operation that we have, such that you consider that the licensing objectives should be promoted by a diminution in the hours? That's what you're invited to conclude. And you're invited to conclude that in the absence of any officers, with 17 representors coming forward out of a community of thousands, and we say that there is no legitimate evidence that would allow for the conclusion that the licensing objectives are undermined, and certainly nothing approximating licensing objectives being undermined such that there would be a conclusion that the hours should in some way be diminished. Does that mean we're perfect? No, of course not. Every single year there is a significant debrief with all of the safety advisory group, and issues will be brought up. This could have been done better. We need to think about this. Should we reposition this? Should we move this? Should we bring this forward? Should we push this back? That sort of engagement happens every year, as it has happened for the last 15 years, less COVID. But there is nothing about our operation that fairly allows for the conclusion that the objectives are undermined. I'll come back to, or when I go through the materials from Mr. Miller, I'll touch on that. Traffic was touched on today, I think, by Mrs. Matthews, and your legal advisor quite fairly said, well, that hadn't been raised in her representation, but it is raised in a couple of the written representations, and you'll be considering those just as you will those who attend before you today. So I'm going to address you briefly on that. There's specific conditions within the licensing, within the license, that attend to issues of traffic. It's all part of the safety advisory group. We have to have a traffic management plan. We have to deliver to the plan. Highways, police, no one has suggested we've done anything other than deliver to the plan. Lighting equally, it's not conditioned in the license, but we mustn't create a nuisance through lighting. I think it's fair to say it can be a nuisance. We need to work carefully in delivering our entertainment in a way that doesn't cause a nuisance. We say unashamedly it does not. Does that mean that every single person is thrilled with us? Self-evidently not. Does that allow for the fair conclusion we're creating a public nuisance? I'm afraid it does not. Over the page onto page 8, I've touched on the diminution in hours that's proposed. One point to make that perhaps you were touching on yourself a little, if I may say so, Chair, is that 17 representations does not allow for the fair conclusion that there is a groundswell of opinion that this license needs to be diminished or revoked. We need to be respectful of the points that are made, and we need to address those points. But it is not fair to say, in the context of the Boomtown event, that that is a very significant number. Whether that is a particular concern or weight today, I'll leave as a matter for you, but it's a point that it's important that I do make. I'm just going now, if I might, just to go through the report a little. That's the main agenda papers. Some just a couple of brief observations. The first is page 13 of your report. Of your main report. You're just reminded of your vibrant local economy priority, and that's a consideration when you come to retire. And just having investigated that a little, the needs of the local economy are part of your considerations. They don't trump the licensing objectives. Nothing trumps the licensing objectives. But you will have seen earlier that on our estimates, something like £17 million a year is delivered into the wider, it's fair to say, local economy through this festival. That's a consideration for you when you come to weigh all of these things in the balance. Dealing then just with the representations, page 25 is Mr. Payne's representation, and again it was a point you picked up on, but a point I will make, that the licensing objective, put simply, is not the protection of tranquility. Boomtown seeks to do its absolute best to intrude as little as possible, but the licensing objectives that it is engaged is the protection of against public nuisance, and the protection of tranquility is respectfully setting the bar in a different place. In terms of Mr. Jones's representation, that's set out on page 39. On page 39, he specifically quotes the Countryside and Wildlife Act and talks about any person intentionally killing. He says at page 40, at the bottom of page 40, in your duties in assessing the application, I would remind you that killing lapwing or skylark or corn bunting or yellowhammers is just as illegal as killing children. I'm not a criminal practitioner, but I would ask you to have a reflection when you see a sentence like that as to the perhaps sensitivity of the author to the issue at hand. What is also clear from this document and the document that was produced today, which re-quotes the intentional killing point, is that there is nothing within any of this material, and in questioning by yourself, Chair, forgive me if it was your legal officer, there is no evidence that can be put in front of you at all to support that candidly outrageous suggestion. And that was Mr. Jones's own admission that he has no such evidence. And I do ask you to reflect on that, and perhaps to, Matt, if your legal officer, reflect on that in the reasons and or your decision in due course. You'll note in passing, I should say, that paragraph 3 of page 40, there's comment about there's no reason to suppose it will vary substantially from previous applications. That's just wrong. You'll note in the 4th paragraph on page 40 that Mr. Jones is providing advice effectively to the farmer who owns the land as to the amount of silage that he needs to produce for his herd. And again, that overreach into territory that is respectfully nothing to do with the licensing objectives, but is an indicator of, to be fair, the passion, but perhaps not the focus that is brought in this representation. I'll be asking you to reflect on and to look at. I'd also say to you, in terms of this alleged criminal activity, where are the Environment Agency? Where are the RSPB? Where are the police who, as we were told today, have a feisty officer who is responsible for this material? Where are any of these officers? Where is the enforcement activity? Where's even the investigation to suggest that we are doing such a thing? And it doesn't exist, to be clear. And the reason it doesn't exist is because it isn't happening. But even if we accept, and I'll be asking you to attach limited weight to documents that are produced on the morning of a hearing that we've not had the opportunity to really reflect on. But on the second page of the material that was produced today, you will see that there is the survey produced of skylarks, yellowhammers, lapwings, and so forth. And as far as I can see, those surveys finished in 2022, not in the main bundle, sir, in the supplementary papers that were produced today. The bundle that effectively seeks to develop the allegation about criminal intentional killing asks you to believe that a survey that appears to have been concluded in 2022 has any probative value as regards the position in 2025. Candidly, I am struggling with that. And if one factors in, if you take the, and I'm no expert in this, so I'm happy to be challenged on this, but if you take the number of yellowhammer seen, which is limited, column second one down, less at Matterley in the 2 years we didn't have a festival because it was cancelled because COVID interrupted it. I mean, you can prove anything with statistics, but it would appear that the lack of a festival very significantly diminished the number of yellowhammer at the Matterley estate. If you want a submission for why we should have a festival, it appears we would significantly improve the population of yellowhammer were the festival to go ahead on the basis of Mr. Jones' statistics. In terms of Mrs. Matthews, very respectful of the points she makes. We engage with her. We engage with her when we're doing our community engagement. We have asked her to get in touch. We've asked to work with her. We have we will happily and have, I think, happily sent out people to her address in order to make sure that she's not being disturbed unreasonably by the event. There is nothing about our resisting the request for revocation or diminution in hours that could fairly be interpreted as being a resistance to engaging with everybody here. We are a very open book, both with officers and residents, and we are entirely happy to continue that dialogue. There is nothing in it for us to annoy our neighbours and local residents. Nothing. Candidly, this is where you end up if you do. So just to be clear in terms of Mrs. Matthews, we are keen to continue to work, keen to keep the engagement and dialogue going. Then, sir, just through your bundle, please, on to page 68 and 69. I'm not going to take you through them line by line, but there are public nuisance conditions that cover the whole of page 67, the whole of page 68, the whole of page 69, most of page 70. We've had the license for 5 years. It's a license that was granted by yourselves or your predecessors, forgive me. We say that we deliver to these conditions. We strive to deliver to them all the time. If you take the whole license, is there any room for improvement in the way we deliver? Yes. Is there any room for improvement in the license? No. These are good standards. You'll see there are particular DV levels and so forth. And we say it with your environmental health officer lead here. I'll be loath to say something that you might later contradict, but these standards work, is what we say, and they are nationally recognised. There's nothing quirky about the standards that are being delivered to Boomtown or imposed upon Boomtown. These are standards that you would hope and expect to see elsewhere. Some events will have greater latitude. No doubt some events may be said to have less, but these are broadly recognised and acceptable standards throughout. And I appreciate each application is on its individual merits, and other festivals are of modest concern to us today. But broadly, there is nothing extraordinary about what you will find within the existing licence. Certainly nothing you would find that would allow for you to conclude we need to change it because of the 17 representations we've received today. So that's candidly probably me, and thank you for the time, everyone. I did in the bottom of the submissions just put some conclusions, just little bullet points. They attend to the points I've covered. You'll have read the materials. When you come to retire, I know that you'll reflect on those. But the simple point, which I'm bound to finish with, please, is that we're respectful of the fact points that have been brought to your attention. But what is the evidence that we have undermined the licensing objectives such that you would want to change the license? That we are applying for a new planning permission, nothing to do with the licensing objectives. That we deliver to the purposes of the South Downs National Park, I appreciate, as you fairly said, maybe something that raises an eyebrow. But what is the evidence that we don't, such that you would conclude the licensing objectives are undermined, such that you would conclude the license needs to be amended? Respectfully, nothing. That's candidly a matter for the authority who deal with the park themselves. We do need to ensure that we are respectful of it. Hopefully the materials we've produced about ecology and so forth fairly set that out. What is the evidence that we are creating a public nuisance? I'm afraid it simply isn't there. And number of residents, many of whom are in very tight proximity to one another, saying they could do better. Well, we'll have to accept that. And we do need to do better. We don't want anyone to say that they have concerns about our operation, but that doesn't allow for the conclusion the public nuisance licensing objective has been undermined. And then the final point, probably the obvious one, is that the suggestion that we are intentionally killing birds and therefore committing a crime is not evidence by the person who made the allegations own admission when asked the question by you. There isn't any evidence of it. And forgive me if I've gone on slightly about that point too long, but you'll understand the sensitivity for the festival. That's a very grave application. Being criticised by officers and residents, well, he didn't do this very well, the gate wasn't manned very well, the traffic was a bit slow. Well, we have to take that criticism on from time to time. We need to pull our socks up and make sure it doesn't happen again. But you're intentionally killing birds? I mean, that's, I'm afraid, beyond the pale. So thank you for the time. Obviously, you may have some questions.
Thank you. Should we proceed straight on, or do you want to break? I'm happy to go straight into questions. Since your last point was about the submission regarding the birds, your contention then is that the information provided by Mr. Terence Jones, your contention is that his evidence is erroneous. That's correct.
Mr. Jones produces a number of statistics and appears to say that based on his analysis, you can fairly conclude that a crime has been committed. So I'm not denying that's what he says. I just don't accept that you could possibly conclude that was a fair submission and agree with him.
But my point is, if you are saying that his observations of the number of birds and the decline in the bird population is inaccurate, what grounds do you?
No, I'm not.
What study do you have you made yourself on the bird populations to say that he's wrong?
So I'm not saying he's wrong. I'm not saying he's wrong at all. I'm saying that his production of materials about the number of birds found in the part of the Natalie estate that he's attended to doesn't allow for any possible conclusion that a crime has been committed. I mean, he said in one point in his earlier submissions, oh, well, the land's the same. Is it? No land's the same. What trees were there? Is there a pond? Is there not a pond? Is there grassland? Is there wheat? Is it barley? Is it potatoes? Is it root crops? Are there cows grazing? Are there sheep grazing? It's simply not anything approximating a professional analysis that would fairly allow for the conclusion that a crime has been committed. That's what I say. And the fact that he can say, oh, well, I only saw 4 yellowhammer in this field in 2022, and I saw 12 in the neighbouring field, and there were less on the Matley estate, doesn't get anywhere near, you must have killed them.
I take your point on the fact that that a crime has not been committed. But if you are, I think the fact that, would I be correct in inferring that on page 6 of your submission that you are going to put in bird boxes, annual checks and appropriate placement? Is that a recognition that there is actually is a problem that needs addressing? Because otherwise, why would you do all these things?
That's as part of the planning permission. We need to be able to ensure that we're delivering to the requirements that we have. And we've got to, as you've seen from the purpose, we've got to conserve and enhance the natural beauty, wildlife and cultural heritage of the area. So our putting forward the basis on which we propose to do that for our new planning permission isn't an admission that we've either killed or that we've diminished the bird population in the past at all. It's we're making an application now. Let us tell you what we're going to do in order to deliver to this purpose.
So Chairman, then the South Downs National Park will inevitably have policies about ecology and what is required for example, biodiversity net gain or enhancing ecological and biodiversity in that particular area. So to meet the policies of South Downs National Park's local plan, you have to do certain things, and part of that may be to enhance the biodiversity offering or the provision of bat boxes or holes in a fence to allow hedgehogs to roam backwards and forwards. So the fact that, as Mr. Phipps rightly said, there is something to do over here in this regime does not necessarily mean that because I'm offering it to meet policies in this regime, that undermines a licensing objective in a very, very different regime. So the two are talking to very different purposes in that sense. So you cannot rely upon the fact that the provision of bird boxes means, therefore, the prevention of crime and disorder objective has been breached, if you like, because they're providing more bat boxes because they're intentionally killing birds. There's too much jumps and inferences being made. They're two separate.
I would say that my line of questioning is interested in the idea of promoting conservation and enhancing the environment rather than,
which is not one of the 4 licensing objectives.
But it's being mindful of
it's being mindful of your wider duty in regards to the South Downs National Park and the Access to the Countryside Act 1949. But your chief task is to turn your mind to the 4 licensing objectives and having the round due regard to those duties in that 1949 Act.
Forgive me for this. Just answer the question in a slightly different way. As a licensing committee, you've got to have regard to the purposes and ensure that they're protected, or do your best to further them by ensuring that they're promoted. Our setting out the activities that we are doing, if you will allow me this slightly hypothetical point, whatever's gone on in the past, are we doing on the basis of the materials we've provided, with the proposals that we make, are we conserving and enhancing the natural beauty? We say we are. I appreciate others will challenge that. But that, I say, alone allows you the comfort of knowing that the authority has considered and is respectful of the purposes. If I said we're not doing anything, don't care about this stuff, I'd be in a very different position. But if I might say so, the analysis of, are you only doing it because you killed some in the past, doesn't really apply to a review hearing about promoting the licensing objectives moving forward. We didn't do that, just to be clear.
I can agree that it doesn't apply.
But it doesn't apply. Yeah, thanks.
With fellow councillors, do you want to go for it?
Forgive me for this, but I've just been given we have to, if our planning permission is granted, and so on, we have to deliver a 10%, or we're expected to deliver a 10% biodiversity net gain. So just to deal with the enhancement point, it's not a neutrality point, it's an improvement point, if that makes sense.
Thank you, Chair. Firstly, I have a question for our lawyers. So on page 12 refers to the human rights. It's considered that Article 8, Article 1 of the first protocol, a right to peaceable enjoyment of possessions, and that may be relevant to our discussion. Can I ask, does that extend to the peaceful enjoyment of drugs if they are within a person's possession?
I think what you need to do is probably look at what we're here today for, councillor. And essentially we're responding to the representors and those 18 representations. Now, the evidence, if you like, in relation to drugs, the main protagonist, the main statutory body tasked with that particular duty is not here today. But I would probably have to understand where you're going with this to able to give you more advice. But the Human Rights Act is one of those background duties. So much like the Access to the Countryside Act that we've been talking about, it's one of those background duties. And the performance of any of our local authority functions, as well as the Equality Act, for example, whenever we turn our mind to exercising our functions, we must have due regard to a multiple manner of things, the Equality Act and the Public Sector Equality Duty, the Human Rights Act. This is why it's in the report, to show that we're turning our mind to these particular points. Because if we don't, we could be judicially reviewed to say that we didn't have this at the forefront of our mind. So by us turning your attention to this and engaging with it, it can be established that you exercised all the correct duties and you were aware of every single duty that we had to perform and exercise to the best of our understanding and ability. The Human Rights Act here is simply, yes, because you're talking about proximity of homes, peaceful enjoyment of property, security, liberty, and indeed the right of the applicant to hold a possession. A license is a possession. So they have also human rights in relation to a physical possession. The right to a license is a possession. So that's why it's there to cover the rights of everyone, not only the individuals who live close to the particular premises itself, in this case, obviously, Boomtown, but also the rights of the respondent here to the review and their right to physical possession of their licence.
Might I, forgive me for this, but might I, councillor, just give you my answer? No would be my answer. We have no, and if you turn to page 182 of the primary bundle, that does set out in broad summary our policy and approach to the topic. The answer you'd get from me is no. There is no claim by anyone in respect of drugs that we would have any respect for. It's an illegal activity, and you will see set out, I hope, and on the preceding pages from Mr. Coombs, all of our endeavours to ensure that we deliver to the highest standards. Are we able to guarantee it? Candidly, no, but forgive me for this, nor is any airport in the country, any port, or any, many nightclubs and so forth. We do our absolute damnedest, though, and it's important you hear that.
Thank you. I note on page 65 the Crime and Drugs Management Plan, page 65, 11, the key outcomes and statistics are after the event are looked at. We're not party to the findings or the recommendations as a result of the death that is mentioned there, nor any changes made to the protocols subsequently. Are you able to appraise us of any changes made to the processes as a result of the post-event analysis, please?
No, I think the fair answer is no, not today, because the conversation is ongoing, and the conversation will be ongoing through the course of the next several weeks. I think you've got a meeting this afternoon. There's actually a meeting this afternoon with one of the team who sit here today, subject to time today, but it's an ongoing conversation. I've got a meeting with the police, I think the 6th of February. The answer is no today. I mean, I'm not saying that to be awkward, but.
Chairman,
I think it's worth mentioning also that we're entering the time of year where meetings will be agreed. Sorry, Tess. Tess would often send me an email, or Dave, or whoever's leading for the safety advisory group, list of dates effectively for safety advisory group meetings. I believe probably following a similar path to last year, where there's 2 main meetings before the event. But as Matthew referred to earlier, there will also be lots of other subgroup meetings with certain individuals or organisations where it doesn't need the whole of the safety advisory group there. So prime example is myself, and then the police licensing officers will attend a bar meeting with Tess and Lauren and the bar companies. There'll be a traffic meeting where the police, highways, so you've got all the smaller meetings, as it were. They start to March, I think. Yeah. So we're entering in that time of year where those discussions will be had with the relevant authorities and the safety advisory group.
I'll have a go. Okay. This is regarding the F1 acoustics report, which I think we might have an advisor coming through the Zoom as well. Specifically, it's regarding what happened on the Wednesday evening of the event, where repeated complaints were made, have been made in the representations from people, saying that there was an issue on Wednesday night, and the response to that has been repeatedly such.
I don't recall whether the complaints triggered us finding it out, or whether it was on we do regular monitoring on the Wednesday, so we have someone going around to each monitoring position in turn, and they keep doing that throughout when the music is playing. So I don't have it in front of me whether it was a complaint that then meant we sent our guy to Sheraton sort of immediately, or whether we discovered it on our regular monitoring. But either one of those ways, we discovered it, and either with the help of residents or not, and then rectified the situation within 15 minutes, half an hour, I believe, off the top of my head.
Thank you. In the submission, you say it was rectified to the satisfaction of Winchester City Council. How did Winchester City Council express its satisfaction if this was an internal operation?
They were also present at the monitoring location. We obviously have close dialogue with them during the event, and they have people out monitoring too. I understand that they were also aware of the location where the music was audible, and they had attended, and that's where the dialogue happened. That they were then subsequently happy that the level had been reduced.
One thing, if I might, it doesn't answer your question, but it may be instructive, is that the environmental health teams and the noise management teams, it is on, sorry, are effectively working together, separately, but together, one as an enforcer, one as a deliverer, throughout the entire event. Rob, it may just be helpful for the chairman if you could just develop that point, explain how you work with the environmental health teams.
Yes, so we have a noise office on site, which is directly next to event control, and the local authority also have an office in the same area. So we have a lot of conversations and dialogue directly with the Winchester City Council officers at the cabin, who are also in communication with their team, who are taking noise measurements off site. The same as we are in constant communication with our team that are taking measurements off site. There is also a meeting every day programmed in where we discuss the previous day, evening and night's noise levels, and we then review in a proactive manner as well the evening ahead. We take a look at the weather, and we may discuss where the monitoring needs to be focused that evening, and just share any thoughts or ideas on potential issues or problems as well. So it's proactive where we can be, and reactive when it needs to be.
Thank you. The reactive part is a concern that you did this in response to complaints that you received, and until the complaints were received, you were unaware of the issue. Would that be a correct interpretation of the situation?
I could look into this for you. It would take some delving into a report to get that exact answer. I can't give you a concrete answer as to whether we came across the exceedance of the criteria on the Wednesday, or whether we were helped by the local community ringing the complaint line to make us aware. But either way, as soon as we were aware, we responded promptly.
Okay, the reason for my line of questioning is to understand whether your noise management plan actually works, because as I understand it, because you rectified the amount of sound within almost immediately, you were in breach of your licensing conditions, which is why you rectified the sound. Is that correct?
So yes. In its simplest form, if the music's inaudible, then if the music is audible and the condition is inaudible, then the only straight answer is yes. But the noise management plan is not reactive in a negative way if residents ring and say we have concerns. That's part and parcel of the noise management plan. The noise management plan provides for a hotline number for anyone to ring if they have concerns about the noise and or operation of the event. From time to time, things will happen, and we will receive calls. At the same time, we have our fixed monitoring points. At the same time, we have our roving monitors. At the same time, we have environmental health roving monitors. At the same time, all are based with colleagues in the centre of the hub or the event control rooms. So that's, if I may say so, the reactive point about residents ringing, it isn't a negative. It's part and parcel of the way in which these things operate. If we take, the technical answer is yes, but if the wind is blowing in a southwesterly direction and it suddenly flips and blows in a northerly direction, it may become audible in the northerly direction. The minute that we're aware of that, we attend to that. So you can call it a breach. Yes, that's right.
I appreciate you accepting that it was a breach.
Yeah.
And I would say that any sort of noise management plan should be preventative. It should be working on the basis that we will not receive complaints, rather than working on the basis that if someone complains, if an issue comes up, then you turn the volume down. It should be, your noise management plan should be, whatever happens, no complaints are going to be received, because we know on site that the volume does not exceed the level it should be.
So yes, but
if I may, sorry. So yes, that is entirely correct, and I agree that the proactive nature is our first and foremost is how we like to respond and manage the sound at the event. We have people who are roaming in the local community throughout any time when there is music playing on site. We have people regularly visiting each of the monitoring positions. And we also have a couple of static monitors that we usually put out each year as well, and those serve us as an early warning system, if you like, to tell us if the noise level is starting to increase. That doesn't mean it's exceeding, but if it's starting to go up, we can then send someone there straight away. So, and we also have teams and monitoring on site as well. So we are constantly monitoring the noise level at all of the main stages on site. That's, again, whenever they've got music on, these monitors are active, and these show the sound level to the sound engineer, who is then responsible for keeping it to a set limit that we have set. So we set those limits to make sure that, barring some meteorological sort of changes that were unforeseen, that we can manage the noise levels so that we proactively keep the sound levels off-site to the conditions that are set. Again, that doesn't mean that people, we might not receive the odd complaint from people, but we stick to the sound levels that are in the premises license conditions by using those proactive techniques that I've just described.
You may prefer to hear it from Ms. Toms, but there isn't anything about the noise management plan that isn't effectively agreed, approved, and has been for a number of years. There's not a, I'm not suggesting you're thinking this, but there is no soft approach here. Well, you can hear from the officers rather than me, but this is a rigorous procedure.
Yeah, I'm working on the assumption that public nuisance is one which is after the nuisance has been caused, rather than that is. It's the same as like graffiti. You can go, if people are complaining about graffiti, it's already too late. The nuisance has already been caused. So I have a couple more questions on this issue.
Mind if you just pick up on your graffiti analogy, though? I'm respectful of that, but if the graffiti is caused and someone rings the council or the freeholder of the property and says there's graffiti on the wall and it's removed 1 minute later, then technically, of course, you're right. It's disappointing that there was graffiti, but the graffiti is no longer there.
I think you've clarified my point there, because that was I thought. So if I can ask Robert Miller, when you discovered the issue with the sound, was it because the front of house person at the event had they exceeded the agreed levels, or were they working within what you consider to be the approved volume?
We set the levels, but the music is a dynamic source. It does change. Sometimes you have different acts. You have a changeover. You might have a change of DJ, a change of band, and at those moments in time, that's when we need to be the most careful with our sound levels. That's not to say also that the wind also plays the direction, plays a very big part in the noise levels that are received off-site, especially when we're talking about the sort of large distances that we are. It can change from, you know, being sort of barely audible, you know, within license conditions, but still audible one day to not being audible at all. And that doesn't mean we've changed the sound levels on site. That's the propagation of the sound levels from the site to that location that have changed. I couldn't tell you without some digging into lots of data the answer to that exact question, but what I can tell you is that it was likely either a atmospheric meteorological change or a sort of changeover that may have caused that. But I think the most important point is that we did discover it and we did react to it quickly. I don't have any record of residents complaining to us on that day through the hotline. I've just looked that up. So I believe it was something that we discovered on the Wednesday and then rectified.
Thank you. You made the point there about atmospheric conditions. Would it be fair for me to say that if the volume, if the perceived volume in various places can be affected by the wind direction changing slightly, you are operating at the upmost threshold of what you can get away with in terms of volume, and the slightest change in wind direction is enough to put you in breach of the conditions?
No, we usually allow a margin, a safety margin on that. And we can obviously look at the weather forecast for the next, you know, the next hour or the next few hours ahead, sort of weather forecast, and we do to be proactive and to make sure that we're identifying potential stages that could cause a problem in the next, you know, in the next period. So I would argue that we're proactively, you know, making sure that we don't go over when a small wind change or direction happens.
So my final question on this point is, would you say that your noise management plan then, if the wind direction changes, you have someone, you radio the stage or the DJ or whatever, and you ask them to turn the music down, or is that how you are that responsive to wind direction, do you think?
Yes, yeah, we have a team of maybe 10 to 15 people who are actually on site as part of the noise management team. And we are monitoring the noise levels at the main stages at the same time. We also have direct communication from the noise office to the sound engineers at some of those major stages as well. So we can get a message that that a certain stage needs to change its noise level or noise output, within minutes. That's how quickly we can communicate that and make sure that those actions are taken.
And sorry, last question. And does that actually occur when the event is in progress? Is that something that, in your experience, happens on a sort of regular basis?
Oh, regularly, yeah. And we have detailed logs of all the actions that we make and all the communication that we have as a team on site. As part of the reporting process, we submit those to Winchester City Council at the end of the event.
Thank you.
Yeah.
Question, councillors?
Carrying on with the sound, most of the complaints we seem to be hearing today is about the bass late at night, because low frequencies do travel a lot further. Do you monitor those and adjust those according to the time of day?
Yes, as you'll see under the premises license conditions, I don't have the number of which one to hand, but we have set low frequency bass conditions, the same as music noise levels off site have to be. There are separate conditions for those bass frequencies that we monitor, and the same process happens. We monitor that, especially we have equipment that can separate out the frequencies, and we measure those in the local communities, and we make sure that we don't exceed the premises license condition that has been agreed for that.
Thank you. Can I ask a further question then? You said to us earlier on that you were reducing the number of people on site during the festival. Does that mean that you'll be reducing the number of people on security?
No, I don't think I did say we're reducing the number, and forgive me, I don't have any recollection of that. But
maybe it was somebody, other people that were speaking.
Yeah, we're not. The numbers of, it was touched on certainly by the chair, I think, and forgive me, it may have been one of the representatives. I think we're referring to the planning application that was seeking to reference to security and stewarding or something, but the number that was given of 16,000 crew, staff, security, steward was right. Actually, I appreciate you thought it sounded wrong, Chair, but it isn't wrong. In fact, I think I was told it was 17,000. So no, nothing about this license is proposed to change any numbers at all.
Yeah, I'm rather concerned with the safety and security of the site when we're looking at the advent of knife crime and the amount of drugs and that sort of policy.
Yeah, no, there's nothing about this license that's proposing to change any of that.
So are you going to increase security?
Well, it'll be part of the safety advisory dialogue. It'll continue to be the same dialogue. We'll continue to have the relationship that we have with all the officers, police and so forth. We risk assess it. If there's a particular quirk, if we take knife crime as an example, that would likely increase the risk. Therefore, the risk would need to mean that we had enhanced numbers on site. But the detail of that I couldn't give you today.
Thank you.
Chairman, if I may, there are conditions that refer to a security plan which are deliberately not providing numbers because it's a working document every year. So this is something that's agreed with the police in advance of the event. On page 137 of your bundle, there's 4 conditions, number 12, 13, 14 and 15, which refer to a security plan. There's an initial plan that's written and sent to Hampshire Constabulary no less than 85 days prior to the event. And then the security plan's approved by Hampshire Constabulary. No alteration to the security plan except with the prior written consent of the police commander for the event, number 14. So, as with a lot of other things, there are conditions attached to the premises license which cover things like security. So that will be adapted each year between the event organisers and the police.
You've probably already seen it, sir, but at 182 is the statement of the crime manager, which runs to about 5 pages. But also at page 187 is the index to the event safety management plan that I touched on, and you will see that the page 191 has crime and security and crowd management and so forth as an example, and you'll find noise within there and all of the various issues, and then it's conditioned on top essentially. So the safety advisory group, I think I called it in my written submissions, is the equivalent of sort of secondary lockstep. There's a condition that we have to have a policy, and then there's the engagement with all of the officers through the safety advisory group as to the content of the policy.
Yeah, are you flexible enough though to change things during the festival if you find things change?
If the senior commander for the constabulary approves it, otherwise no. Well, let me, by the way, we can't, but they can.
If I can return to the public nuisance thing, and you brought up the idea that the consideration that we should another consideration of the council's strategic outcome, the vibrant local economy. So I have a few questions which will lead towards that. Firstly is, how would you characterise the music that the event has from about midnight to 4 o'clock in the morning?
I mean, diverse, it would be a range of all sorts. I mean, there'd be dozens of music genres. Yeah. Okay, but the nature of the event is this is music for people to dance to, rather than chill out and relax on the hills going, this is lovely bit of, you know, the Orb or Goldfrap where we can just, it would be nice to send us to sleep. This is music designed to get people dancing and keep them dancing. Yeah, yes, I'm not sure we quite agree with that. There's plenty of areas that are chill out or as you refer, I'm not going to get into an analysis of the artists with you. I'm not in any candidly position to, but there is lots of provision for people to dance, yes. But the provision is for people to be entertained, whether they choose to dance or not, it's up to them. And some of that entertainment is you can sit on a field in a deck chair. Some of it is you can be in the front of a tent dancing.
But in terms of the music that carries to other areas and is the cause of the complaints, that would be the dance music, wouldn't it?
Yes.
Yes, obviously. So my question is, in terms of the vibrant local economy, how essential is it that you have loud dance music going till 4 in the morning?
Oh,
in terms of the event's viability?
Again, it's very easy. There's no event without it. Full stop. With a 12 midnight finish on Friday and Saturday, there's no event.
Obviously, there are gradations here. Would you then, if I argue that if a 3:30 in the morning finish, there's no event without that?
What I would say on that is that I'd be overextending to say there was no event. But what I would say is there's no evidential basis for that to be a reasonable conclusion of the licensing committee this afternoon. I'm sorry. I'm not here to be rude, but I would have to make the submission to you. There's no evidence that would reasonably support that conclusion. But that would be a different answer to the would there be an event?
No, I mean it's useful in terms of weighing up the arguments. Going, you've said that the purpose of this event is to have loud dance music up until 4 o'clock in the morning, which is of concern to local residents.
So yes, I think is the only straight answer for you. We have a license already where residents have brought to your attention concerns about noise. The license is the license. The license has been established for a number of years with the hours that it has. There are concerns expressed, as you will have seen, about Wednesday night. The music was audible. Wednesday night, of course, finishes at midnight, not at 4. And there have been a couple of comments about the Friday and Saturday. Sorry, it's earlier than that on Wednesday, forgive me. Anyway, and there have been comments about the Friday and Saturday night, but there is nothing, respectfully, that would approximate sufficient evidence to conclude that the promotion of the licensing objectives would be best served by reducing the licensing hours on Friday and Saturday, is our submission to you. That's for you as to whether you agree.
And it's in the character of submission that all the other things that Boomtown has to offer in terms of the daytime music, the events, the food, the sculptures, that is by the by, and the purpose of the event is to have music from midnight to 4 in the morning. Because you've said without that, the event is not viable.
Whether it's just the use of the word purpose, I don't know about the use of the word purpose. All of a festival is massively multi-dynamic, with every feature of it being of significance and importance. But undoubtedly, and by the way, obviously this is about Boomtown, but this is true of every festival. Late night dancing is an associate, and sale of alcohol and late night refreshment are a specific feature of almost every single festival in the country. Some are later than 4, some are earlier than 4. Ours is 4.
If I can, so having looked at the schedule of the event, the music stops at 4 in the morning, and then people go back to their tents, and the event starts at 9 o'clock the following morning. So the basis for the schedule is that the attendees get about 5 hours sleep per night. Is that right?
The amount the attendees sleep is respectfully a matter for the attendees. There is no obligation on anyone to get up at 9 a.m. There's no obligation on anyone to go to bed at 4 in the morning. You could choose to sleep in. You could choose to go to bed at 10 at night. And these, people come to camp and to enjoy the parts of the festival that they enjoy. Some people enjoy the late night activities. Some people enjoy the early morning activities. But
So if I understand you right, you're saying that it's possible for people sleeping in a tent on the site at 10 o'clock at night to fall asleep because of with the level of music.
Yes, absolutely. That happens at all festivals, sir. A lot of festivals have children. A lot of people go back to their tents with their children. The degree to which one is sensitive to the noise is a matter of personal perception. There will be people sleeping in a tent under effectively a tarpaulin at 10 p.m, 11 p.m, 12 p.m, 1 p.m. at this site in the camping areas. Absolutely, yes. And that's true of every festival in the country. Sorry. Yeah, half the staff would be a good example, because of course people do shift work. Not everybody's working all the time, so people do different shifts. Some people go to bed at 9 in order to do a shift at 8 in the morning. Some people go to bed at 4 in the morning in order to start a shift at 12 noon. So yes, there will always be people sleep. I mean, there's probably always someone sleeping on the site at all times.
And I appreciate the clarification, because clearly the one argument you would make, therefore, is that if people are capable of falling asleep on the site at midnight, then someone who is 6 miles away should also be able to fall asleep.
I mean, obviously, I hear that, and I respect the point, but it doesn't fundamentally change our point. Our point is, does this event cause a public nuisance? And the answer to that is no. If you take as the evidence for that, there are people sleeping on site at the time, and that may be a window into, if I may use the language, a window into the soul of the sensitivity of others who live further away. That's a matter for you when you come to deliberate. But there are people sleeping all the time.
Thank you. I hope our legal advice hasn't found that too irrelevant. Any further questions?
Excuse me. Yes, going back to Annex 3, page 135, the Crime and Drugs Management Plan. It says, insofar as it relates to drugs, shall address and seek to minimise the use, consumption and supply, and that persons found attempting to enter the event would be ejected, and how the PLH will deal with persons found in possession of illegal drugs and banned psychoactive substances within the licensed premises. I appreciate that is subject to ongoing discussions, etc. But would you be averse to that being conditioned, a potential tightening up of the conditions of the licence, to say that any person entering the event and found to be in possession of unlawful drugs should be refused entry? And furthermore, any person found in the event in possession of unlawful drugs should be ejected?
Yes, Councillor. Sorry to, again, give you such a direct answer. The police made an application that when they reflected on, they withdrew. They made a request in that original application for the conditions you've just read out, which they then withdrew entirely. We can't support the attachment of a condition that the police themselves have concluded are inappropriate.
Another line of questioning is regarding many of the complaints are that regarding the objectives of the South Downs National Park, particularly Purpose 1, that it is there for people to enjoy the park and enhance. It's to enhance people's appreciation of the national park. Well, Purpose 2, sorry. With regards to that, why has the event chosen the South Downs National Park as a venue?
The event's been at the site since 2010. The park was only designated in 2010. I can't tell you whether the park had been designated before the event was chosen. I don't know. Is the straight up?
It was the natural beauty of the place that attracted us. We're aware it was a park. It was in the process of becoming a park when we chose the site. It's just an attractive part of the country, and it was part of the appeal. So.
Thank you. It's a useful response, because my understanding of the festival is that it's fenced off and most of the events are undercover in tents, and the part of the appeal of the event is that you build these new sculptures around the stages and so forth. So my question is, surely the appeal of the event is the fact that it's Boomtown and not the fact that it's the South Downs, because when people go to Boomtown, their experience of the South Downs is minimal, to say the least.
Sorry, so no, I'm not sure where you have the idea that most of the event site is covered. That just respectfully is just wrong. Sorry. There are covers, there are tents, there are some of the spaces are marquees and so forth. But the idea that most of the, I mean, it would take an awful lot of tarpaulin to cover the event site. So I couldn't respectfully accept that. And the point we make is this: people come to the park, and they may well come as a result of coming to Boomtown, but they can enjoy the park as much as they can enjoy Boomtown. And but for Boomtown, for some of them, they may not have been to the park, and for many who go to the Boomtown, they may choose to come back to the park. So how people, we're almost in, if I may say so, a discussion of how people enjoy the park. Some people enjoy the park for the birds. Some people enjoy the park for the walk. Some people enjoy it for the trees. Some are enjoying it for a music event. That's not illegitimate. If we look at Purpose 1, it talks about the cultural heritage of the area. The event's been going for 15 years, part of the cultural heritage. It doesn't say long-term 250-year-ago cultural heritage. Some of the cultural heritage of the event is Boomtown.
I appreciate your point, and I appreciate the correction on what proportion of the event is under tents, which is, but when you go to one of these festivals, it's all the stuff that is brought to the location, which is the actual festival. And so my point is, if there was another venue, Boomtown could continue to successfully somewhere else, which wasn't the South Downs. It's not, the South Downs is not your selling point. Your selling point is Boomtown. Is that correct?
I think that is correct.
The selling point is the South Downs. In all our outward comms, we're referencing the South Downs National Park. We're selling the whole park as an experience. We're encouraging people to come back to the park after they come to the Boomtown. They're camping for 5 days. They're outdoors. They can see the dark skies. Our whole piece is the park. And quite a large number of the event spaces in the woodlands. People, yeah, it's definitely not an undercover event. It's about getting involved in the nature. With so many panel talks and discussions, and much of the content is around being in the park.
My final point is that so the reason it takes place in the South Downs is to encourage people to appreciate the tranquility and the nature of the area, which otherwise the event is disturbing.
Forgive me, I'm really sorry. Although, as you know, I did originally submit that the licensing committee is not the place to do a careful analysis of whether the purposes of the South Downs National Park Authority are being promoted. We were merely, as per the licensing policy, there to respect them. That isn't what the purposes say. We have to conserve and enhance the natural beauty, wildlife and cultural heritage of the area, which We have presented to you, whether you believe us or not, we presented to you that we do, and we have to promote opportunities for the understanding and enjoyment of the special qualities of the park by the public, which we say to you unashamed.
The people who come to dance till 4 in the morning, who are going, you've enjoyed dancing till 4. The people who come to dance till 4 in the morning, who are going, you've enjoyed dancing till 4 in the morning. Why not have a nice walk on the quiet hills the next day?
So we might, sir, but no, we don't need respectfully to say that. And your legal officer will advise you quite what this has got to do with licensing objectives is a little lost on me respectfully. But people will come for different reasons. Not everybody is coming for the same reason to Boomtown. Not everybody comes for the same reason to the South Downs National Park. Some people want to fly a kite. Some people would find it irritating that the kite is disturbing their view. Some people come to Boomtown in order to do daytime activities, in order to go to talks, to have some beers with some friends, to enjoy the food, to see a particular artist. Some people don't do that. Some people lie in a hammock all afternoon reading a book. Some people want to dance till 4 in the morning. Respectfully, we can't pigeonhole Boomtown attendees as though they are one individual. They are many thousands of different individuals, just as the attendees at the South Downs National Park are many thousands of different attendees coming for many thousands of different reasons.
My last point on this is just, I appreciate that you've now made the point that you have a diverse number of attendees who are not all attending there so that they can dance till 4 in the morning. So your previous point that is essential to the event's success, you seem to have contradicted yourself there.
No, sir, I haven't.
Yeah, we're getting into cross-examination now. I think between the parties, I think the points have been made, and we're not meant to cross-examine. This is meant to be a roundtable conversation on the licensing objectives. I think the point's been made, Mr. Phipps. The answers have been provided, and I think we take it away is where we're going, Chair, because this is wholly outside the licensing objectives and moving into cross-examination. I think that's probably where we draw the line.
I accept the cross-examination point, but I'm not adverse to the challenge. But I would like the opportunity to answer the question though, because the question's been asked, and if we don't have a response, then you only have the question, and there's maybe a presumption the question was respectfully a good question that had validity. No, some people dance until late at night, and that volume and proportion of people, they may choose to dance on a Friday, they may not choose to dance on a Saturday. So the idea that the whole event has all of the people dancing at all of the time, and that is the basis on which the 4 a.m. is necessary, is misconstrued. They are inextricably interlinked one with the other. The 4 a.m. is essential. People come for a variety of reasons, might choose to do something different on a Wednesday than they do on a Thursday, than they do on a Saturday, than they do on a Friday. So one doesn't get to cherry pick it, I'm sorry. And then I'm bound to say, respectfully, quite what this has to do with licensing objectives, I'll leave you to consider in your reflections.
I would just say it was in terms of licensing objectives because it's giving you a chance to restate the rationale for having a license till 4 o'clock in the morning.
But we're not making an application. We're hearing a review. We have not made an application. We're hearing a review where the applicant, all the drug issue, withdrew entirely, but we hopefully have answered respectfully. And we have evidence about planning permission from the representors, South Downs National Park, and the fact that the purposes need to be respected by the licensing committee. We have concerns about noise, and we have reference to crime being committed as a result of our intentionally killing birds. That's the focus of the review, if I may say so.
Thank you. Any further questions from my fellow councillors? Yep.
Yeah. Sorry, a point of clarification, if I may. In terms of reviewing the licence, we are looking at the licence in its entirety, not simply on the issue of the birds or the noise.
You're reviewing based upon the representations that's been submitted in the bundle and expanded upon today.
As we have no applicant review, do we move to councillor discussion then?
Yes, Chairman, there's no applicant for review to sum up or effectively summarise their application today. So we've moved on in the agenda, which would be for the committee to retire to make the decision. What I would probably say is, given that it's 2:15, whether there's a reasonable expectation that people can have lunch and an earliest time for people to come back to the meeting room before you may make your deliberations and come back with a decision. Just to allow people to go and get some lunch before they know they have to be back here in case you've made your decision. So I would probably say at the earliest 3 o'clock, which will allow you time to get, I don't know, is 45 minutes or an hour enough?
I think
If you will be back when you tell us to be back.
Has to be mindful that officers obviously have to go and get lunch as well. So we're office employees and there's times for breaks. So yeah.
I think if we convene at 3 o'clock then.
I think it's just worth mentioning so that everybody can get lunch and they know there's a time to be back for. That doesn't mean to say that you will have made your decision then. It means that this is a time to be back, ready, waiting for when you have made your decision.
We'll reconvene at 3 o'clock then. Thank you.
Thank you.